Yeah. Serial number 1. Item 1. Pronouncement of yeah, just to make pronouncement. No, why you are not but you cannot go leaving the first matter without bounds. 1 minute, there is definitely correction. There is someone. Yes. But you are not here. Yes. I have broadly accepted contention of the applicant, and I have allowed that application for restoration because even the petitioner said that it should be decided by other lawyers. I have not agreed with the allegation that he had suppressed anything. In fact, he did not suppress. But that being said, certain wild allegations are made against a sitting judge of this court. So I very, very carefully perused all the papers. Then I felt papers should be placed at the hands of Honorable the Chief Justice for taking a decision as to whether the action for criminal contempt of court or the offense of contempt of court it should be prosecuted or not. I have not said initiate, not initiate. I have only said, in my view, matter requires consideration at the hands of Honorable the Chief Justice. And therefore, I have directed the registry to place the papers accordingly. I have also directed the registry to place petition papers at the hands of roster judge. My order reads this way. The application in IA number 16218 of 2025 having been favored, the final order dated 9/9/2025 is hereby recalled, and as a consequence, the petition is restored to the court. Registry to post the matter before the roster bench after taking orders of Honorable the Chief Justice if need be. 2. The registry is directed to place immediately a set of case papers in the subject petition at the hands of Honorable the Chief Justice for examination as to whether the matter merits initiation of action against the petitioner for the offense of contempt of court under Article 250 of the Constitution of India and or the provisions of Section 11 of the Contempt of Courts Act 1971 or otherwise. Third, the registry is directed not to grant certified copies of record of this petition or any part thereof to any person, nor shall anyone be permitted to look into the said record, hard or digital, save with the leave of Honorable the Chief Justice. And further, that the entire record were filed be masked. Fourth one. As a consequence of the above point number 1, it is for the roster bench to decide the fate of petitioner's application in IA number 18345 of 2025 when the main matter is placed at its hands. Last 5, the application in IA number 16219 of 2025 seeking stay of a part of operative portion of the order dated 9/9/2025, which is since recalled, is disposed of as having become infructuous. Yeah. Yes. Item 2.
Well, pursuant to your earlier order of your losses,
Yeah.
my application, my representation for
It's rejected
under Annexure 12.
That representation was for
appointment from the date of appointment of the candidate who was settled less marks than me. I have given the instances in my writ petition.
To take notice, sir, Mr. Go to first statement. Any private party?
No private party, only for extra copies.
Yes, issue. Yes. Mr. Mohanty, the DG requested also notice for OPs. Item 3.
Item 3 in identical matters, the Lordships have already issued notice.
Then, follow on. Item 4.
The petitioner is a retired government servant. After 30 years of completion of service, my lord, he claimed for third MSc, my lord. And the headmaster also sent the proposal, my lord, to OP number 3, my lord. The petitioner made a representation to OP number 2, my lord, which is pending for disposal, my lord. My lord.
The short
Annexure 5.
Annexure 5.
All OPs you are?
OP number 2, my lord.
OP number 2.
My lord.
Yeah. Petitioner has made a representation to OP number 2 on 12/8/2025, and the same is available at Annexure 5. In the said representation reads as that. Next one. The petitioner submits that if a direction is issued to consider the subject representation in a time-bound way, his client would be satisfied. Mr. Mohanty, learned AGA, very fairly submits that he would instruct OP number 2 to take a call on the subject representation in a time-bound way if contentions are kept open and a reasonable period is prescribed for accomplishing loss. First, with this proposal, counsel for the petitioner is agreeable. Next paragraph. 8 weeks. Contentions kept open to solicit. Now no cause. Well, copy. Yes.
Public.
Item 5.
Yes.
This petitioner is a CRPF sub-inspector.
Correctly, petitioner father.
Yes,
Anderson.
he has even from school time it is forwarded to the board. When he joined, he filed an affidavit before the authority to correct it. In school certificate, in the entry point, everywhere.
Mr. Rao appears, na?
Normally.
Let him take notice. Survey copy.
Yes, I am, sir.
Okay. Issue emergency.
Is for OP number 1.
Mr. Rao, the panel counsel is requested to subject to request notice for OP number 1. Learned AG and Mr. Hon'Ble on request accepts notice for 2 and 3. 2
and 3.
2 Yes. The matter lies in a narrow compass. Post it on 12th. 12th of
The merge of retirement, he will.
Therefore,
there will problem.
Yes,
Yes, sir.
you give copy. Item 6.
Item 6 may please, Your Lordship. Your Lordship, I'm challenging the order of recovery. However, Your Lordship, inadvertently, instead of the impugned order, a wrong order has been annexed, Your Lordship. I may be given a chance to make necessary corrections, Your Lordship.
You want to make necessary correction? Let us move an application.
Your Lordship?
Move an application.
Yes, Your Lordship.
The petitioner seeks some time to move an application for effecting certain rectification. First of all, after 2 months.
Obligation.
Item 7.
It's a matter of pension, my lord, of I added a higher secondary school. The petitioner is the wife of a deceased, that is a clerk of a higher secondary school, died in 1999 after 25 years continuous service. Thereafter, he is all pension benefit and pension has not yet been released Annexure 6 on page 44, kindly at a glance, my lord. Though the control of accounts had remitted the matter only to regarding the higher finance upgradation and the that is the subject to complete of accounts training, that is on running page 45. So that is compared on the very day, but the department is sitting over the case,
Some criminal case.
Criminal case that was against my husband. That husband was died. That was police had failed to place any paper against me. Thereafter, that matter is not continued. Still, then I have come to the Hon'Ble Court. The Hon'Ble Court has directed the same. That is also I have alleged.
You take a notice, Mr.
My lord.
My lords, only he has to give the copy in GR case that it is closed. That is what.
That is given.
That information is not with the authorities.
That is
Referred to that GR case.
GR case, my lord. That is against my husband.
Correct.
My husband died.
All right.
Total abated.
No, that
According, though in Honorable High Court also died accordingly.
no.
That is on page 1619.
That's all.
Annexure 4.
You have to give a copy of that order, no?
And I have given that.
You have given a copy now.
Before the authority.
Annexed that same.
Which one?
Annexed
Mr.
running page
Just look
16.
into.
Man.
I will call this matter week after next. In pension matters,
My
I
lord.
am bit.
Is getting provisional pension.
But revision here sorted.
My lords.
Any representation you have given, that is rejected.
That is rejected. That is on the ground of that.
You accept notice.
My lords,
And come
the
back to
controller of accounts has called for reports, resubmission of the papers. He was called to give the copy of the GR case, that it is closed, so that they can submit before the controller of accounts.
Now he has produced all copies.
He has not given that.
There are copy here.
Yes, I have given out also.
26 of 2005 produced. And where is that GR case? Order of GR case.
Their case, my lord, that is a running annexure 4, running page 19. That is the Honorable Court had directed the same to conclude the GR case, but that due to non-ability to record for the court below, so that matter has not been, there is no any order in the court below. There is no any order at the court below. Because the records are not available at the court.
Anyway, just you look into, if what is required, you will
Your lordship may give 2 weeks time.
issue the appointment notice. The background of the DGA on request for subs notice for 124. Governing body also.
Also, man.
You okay for governing body?
Governing body have to take
To
notice.
project notice to 5. Returnable within 2 weeks. Post immediately after service.
Item 8. May I please, James? Petitioner, my lord, is a government servant, my lord. He is seeking transfer of annexure to the impugned order, my lord, passed by the DO Koraput, my lord. And my representation is pending before the collector of Koraput, my lord. And that is, my lord.
Representation against the transfer.
Yes, ma'am.
Transfer order is dated.
6/10/2025, ma'am.
Petitioner is knocking at the doors of this court for laying a challenge to the transfer order dated 6/10/2025. A copy whereof avails upon in the 2, wherein his name appears, figures at serial number.
Serial number 42.
44.
42, ma'am.
Serial number 42. Personally. Learned counsel for the petitioner submits that in terms of decision of the apex court in Varadhara, state of Karnataka, his client had already made a representation dated 8/10/2025, seeking halting of the transfer in questions in the given circumstances. And that the same has not been considered by the OP number.
OP number 3, my lord.
OP number 3, who ought to have taken a call thereon within a reasonable time regarding had to the urgency the further adds that his client will be satisfied if the direction is issued for the consideration of this representation on its intrinsic merits and within a reasonable time. First, next paragraph. The learned counsel, Mr. Behra will consider that.
My lord.
Learned counsel, Mr. ITL, Mr. Behra, appearing for all OPs, very fairly submits that he would instruct OP number 2 to look into the grievance of the petitioner as has been urged in the subject of presentation if all contentions are kept open and a reasonable period is accorded. First, counsel for the petitioner is agreeable with this proposition. Next, in the above circumstances, petition is before law. 8 weeks, all contentions kept open. Are you relieved or not yet relieved?
Not yet.
Petitioner shall not be relieved from the present place, and that he shall be continued in the same place.
My lord, see, not if, not if, my lord.
Unless he is already relieved. Yes, no point.
Subitem is also same.
Same.
My lord.
His serial number?
My lord.
Transfer serial number.
First one is 50, second one is 42, my lord.
First one is?
50, my lord.
50.
Second one,
50.
my lord, 50.
Second one is
42.
Oh.
Oh, bless.
The old time rule. Old time
Item 9.
Rejection order is under challenge, Annex 2. That is, in the previously, the petitioner had filed a petition claiming certain reliefs. That was rejected. While rejected, they did not whisper a single word regarding the prayer of the petitioner, but rejected on some other ground. I had prayed in the previous writ application. I had prayed for. Here, let me kindly come to page number 4, last one. Here, on utilized leave salary. Yes.
Yes.
Item 10.
Yes. May it please, Your Lordship.
Yes.
The petitioner is an assistant block education officer. He belongs to level 2 of the elementary cadre. Well, that's level 2. Well, as per the extant rules, my lord, that is as per rule 11.5. Rule 15, well, explanation for a appended to rule. No, well, only 1 year and 5 months left for his service. Well, as per rule, as per explanation 4A to rule 15.
Page number?
My lord, 532. Your Lordship may kindly see.
Just read. Whenever such rules are brought, it becomes easy for me to take a xerox of that.
That is available in the education manual.
With us?
Yes. Page 532.
What it says?
Well, it says that seniority is to be counted from the date of entry into level 2 of the service. But while publishing the provisional gradation list, they have reckoned my seniority and vis-a-vis others from the date of entry into level 3 of the elementary service.
Level 2 it ought to have been.
Yes.
Read that.
Well, Your Lordship may kindly see page 532, explanation 4A, appended to rule 15. All persons now working as regular deputy inspector of schools and senior coordinators, non-formal education, shall be treated as members of level 2 of the service. That is in addition to level 2 of the service. So far as assistant
seniority of such person shall be determined from the date of their holding the post as
holding the post. And now Your Lordship may kindly see rule 3, who are coming within level 2. My Lord may kindly come to page 521. Constitution of service. My Lord may kindly see 315, the Odisha Elementary Education Service level 2. My Lord may kindly come to next page. Roman 4. The Odisha Elementary Education Service level 2 shall consist of the following categories of posts.
Block education
Assistant block education officer also.
Posts also.
Yes. So my submission is seniority is to be reckoned from the date of entry into level 2 of the service. But now Your Lordship may kindly see Annexure 7 while preparing the provisional gradation list.
Anyway, now provisional gradation list is prepared.
Yes.
And
I have filed objection. I have also filed objection.
Let them consider the objection.
But yes. And before publication of final gradation list, no promotion to level 1 may be made. Because earlier I have already suffered 1 round.
That's all right. The promotion to be made or not, it's a matter of public interest. If you are aggrieved,
yes,
you will get everything.
Yes, yes.
That's fine.
Yes.
Therefore, we will say that your objections to the draft gradation list needs to be duly considered.
Duly considered. That is under Annexure 8. Annexure 8.
That the draft list is where?
Draft list. Annexure 7. It was published on 24/9/2025. Page 93.
24/9.
25. And my serial number is 90.
Annexure.
Annexure 7.
And your representation?
My representation Annexure 8.
Dated?
4/10/2025. Within time I have filed.
Your apprehension is it may not be considered and they may proceed with that only.
Yes. Earlier that has happened and I filed a writ petition. That writ petition is pending.
It's also pending.
Yes.
So we direct the consideration of your representation.
Yes.
While finalizing the gradation.
Yes. Annexure 7.
Annexure 7. Okay.
Yes.
Next one. The short failure decision.
Yes.
The short grievance of the petitioner is more in the nature of apprehension that his representation dated 4/10/2025, a copy whereof avails at Annexure AA, filed against the draft gradation list dated 24/9/2025, a copy whereof avails at Annexure A7, may not be considered while concluding and finalizing the said list. Learned counsel submits that counsel for the petitioner submits that he was before this court. He is before this court in another case,
That is
namely WP number
28421 of 2025.
25,
That is pending.
which is pending. Full stop. He adds that if a direction is issued to consider his client's representation on its intrinsic merits while finalizing the gradation list, that would satisfy the need of justice. First off. He further submits that in the fitness of things, the jurisdictional OPs should be interdicted from operating the draft gradation list for the purpose of higher placement or promotion. First one. Next one. What do you say, Mr. Behera?
My lords.
For consideration, you have no issue.
No.
For the prayer that draft gradation list shall not be, suppose if I say,
My lords, it is
then,
general.
they may operate based upon my observation. Because Supreme Court said,
Yes.
even draft gradation, crashed gradation list can be acted upon. Kathe Gowda versus State of
Yes,
Kerala.
yes. Yes.
Therefore, what I suggest is, let them consider your representation.
Yes.
Next one. Learned AGA, Mr. Behura, appearing on request appearing for the OPs, very fairly agrees that it is the normative procedure that objections to the draft gradation list have to be considered before finalizing the same. And therefore, that course would be undertaken by the officers. First of all, this would satisfy the first prayer of the petition. First. So for a second prayer as to interdicting operation of the draft gradation list time, learned counsel for the petitioner rightly submits that ordinarily it should not be acted upon, and if there are special circumstances, perhaps an otherwise decision may be taken. First off, this is absolutely fair. Next one. In the above circumstances, petition is disposed of. The petitioner's representation dated 4/10/2025 at Annexure AA shall be duly considered
OP number 2.
by OP number 2 while finalizing the draft gradation list dated 24/9/2025, at annexure A7. First, in the above observations, petition is disposed of. Firstly,
Your Lordship, may I add only one thing. By taking into consideration Rule 15 explanation 4A.
it hardly needs to be mentioned that the jurisdictional authority shall keep in view the provisions of
Rule 15 explanation 4A, Roman 4A.
Rule 15 explanation
4A.
Write down and give that of so and so rule.
Yes, Elementary Cadre Rules 97.
Give that. In addition to other extant rules,
Yes.
if any. Okay.
Item 11.
Relates to release of group A senior lecture skill and also.
This will render your first petition infructuous, perhaps.
No, first, so far as the first petition is concerned, rejection order has been passed and that rejection order is under challenge.
Yes, brother.
Yes.
Yeah.
Matter relates to release of group A senior lecture and it was identical.
One line you have to add, no? That's what we see over there. You copy to
Yes, already.
all the same
Yes.
annexes.
Yes, ma'am.
Annexes need not be mentioned.
No. I have pointed out, my lord, that is to be mentioned
Copy.
as per my impression, ma'am.
You have to give copy. To
Yes, already submitted.
Submit it.
Yes. Always done.
Item 12.
In this case, my lord, the petition challenged the transfer order under Annexure 7, my lord, violating the order of the Annexure 8, the spouse guidelines, my lord.
Vogel case.
Yes, my lord.
What we have done in similar matters.
In similar matters, your lordship,
Take that.
it is in the 145 kilometers, but in the present case, it is 45 kilometers. And the wife is working from the present school to 7 kilometers, my lord.
Whether relieved or not.
It's not really, my lord.
Not yet relieved.
No. Maybe relieved today, but they have a process. But I have got the information from the anybody.
Order copy of the.
Yes, Mr. Yes,
My lord.
we'll dispose of this matter in terms of that order.
Lordship.
Identical matter.
My lord.
The subject matter of this petition is substantially similar to the one in WPC 29006 of 2025 between Neelamani Padhi versus State and others. Disposed of by this bench, wide order dated 15/10/2025. First, the operative portion of the said order reads as next one.
Here I may be permitted in this case, my reference are already filed, but I have not filed the representation in this case.
You have to make a representation now.
I may be permitted, I will file the representation first, my lord.
No, there also we have said representation is to be made.
My lord.
Reads as okay. Next paragraph.
Audience
It is a normative principle of adjudication that like cases should be treated alike, subject to all just exceptions into which argued case of the petitioner does not fit. And therefore, whatever relief has been granted to similarly circumstanced litigant cannot be denied to the petitioner as rightly submitted by the council of the for the petition. Next one. In the above circumstances, this petition is also disposed of in terms of the order made in the cognate petition. Mutatis mutandis.
Let's me only say if not relief, madam. The transfer order issued is 13th/10.
The relief granted to the petitioner for continuing him shall not apply if he is already relieved.
I'm not a relief. I'm not a relief till today.
That's therefore.
Item 13.
May appear. If the petitioner made the second round litigation, now the prayer for proposal submitted for reconstitution of the governing managing committee has been rejected by Annexure 7.
On what ground they agree?
Rejected that some procedural error has been committed by the petitioner while submitting the proposal. Now, my lord, also kindly see the one ground that they have assigned annexure 7, that headmaster Lakshmindar Patnaik, headmaster of Kalakanu High School, he has stated that he has never informed regarding such meeting for constitution of the MC and also not present in the meeting. That is also, my lord, totally contrary to the record. Also kindly see annex page 36. That headmaster already recommended to the DO on 9/8/24 and also put the signature in the resolution book as everything. Now, my lord, the opinion number 3, without considering the same, now rejected in a very mechanical manner.
Take notice, sir, my lord. Issue emergent notice. ASC requested to accept notice for all OPs.
All of us.
For headmaster also.
Headmaster, this is also a government high school.
Matter lies in an error compass and you are pressing anything?
Because they are now the DO is saying, in order to nullify the claim of the petitioner, now in the meantime they have already demoted the petitioner from the post of headmaster to assistant teacher. That I have challenged in the other case. You also already issued notice in that matter.
We'll call both the matters.
Yes, both the matter.
Next week only.
Only interim order they subject to return. Any action taken pursuant to annexure 7?
But this is, this application, reconstitution managing committee,
Yes.
Yes. Well, she has no role to play,
Now the person is continuing junior person.
See that. Let this matter, call this matter.
Yes, sorted.
WP number.
I have given the number.
she transfer Olga ki reconstitution managing.
My lord, that's an identical matter. Loksev has already issued notice in this case.
Same. There is any change. Yes, sir.
Item 15.
Please, Your Honor. The matter relating to release of UGC scale of pay, my lord, in favor of the petitioner, the retired person.
Other matters. In other matters, what we have done? Consideration of representation we do.
Yesterday,
Annexure 4 is the representation.
You can you can't keep it pending.
Lordship.
Petitioners representation dated what is the date?
6/5/2025.
6/5/2025, a copy whereof avails at annexure 4, having been kept pending, comma. He is bringing, he or she,
my lord.
is bringing before the report against the sin. First of all. Learned AGA very clearly submits that there would be no difficulty for consideration of the representation if the petitioner also furnishes required document in that condition. First, this is a fiction. He caveats that all contentions of the party will be kept open. First, with this counsel for the petitioner is next 8 weeks. All right? Next.
Item 15.
Item 16, the candidature of the petitioner was not considered for the post of Hindi teacher pursuant to the advertisement on Annexure 1. She had earlier approached this Honorable Court for consideration of a case. This Honorable Court at page 54 had directed for consideration of her representation. Her representation has been rejected at page 57, Annexure 12, solely on the ground she has 44% temporary disability, Your Lordship.
44% temporary disability.
My lord. But the advertisement
requirement is 40% permanent disability.
Permanent, Your Lordship, only may kindly see page.
It is not permanent.
No, it is temporary.
That is, it has been written for permanent only for seeking age relaxation. That is at page 19. Page 19.
When it becomes a temporary disability?
My lord. My lord, it is the order reveals, my lord, paragraph 5 of page 58, Your Lordship. Whereas, in compliance with the directions issued by the Honorable High Court, the petitioner submitted her representation before the State Selection Board. Upon meticulous examination of the documents furnished by the petitioner, it transpired from the disability certificate provided by her under Annexure 4 that she has been assessed with 44% temporary disability in relation to her auditory function. However, as per express provision stipulated under the
Hearing impairment.
yes,
Hearing impairment.
HI, yes.
What is the job?
Hindi teacher.
Hindi teacher. We have appointed 45% hearing impairment persons as judges. And the apex court upheld it. Madras High Court, in Madras High Court, they said you cannot work as a judge with that much impairment. The apex court said you can just look it. You accept notice and let us what will happen. File short statement of objection. So have you brought that judgment of Madras High Court? You not brought. G is requested to accept notice for office. Matter lays in the narrow compass and
OP 1 and 2, my learned senior will accept. For OP number 3, Mr. Samir Kumar Das appears.
Sir, copy.
One post may be kept vacant because pursuant to the earlier direction, the post is still lying vacant. Your Lordship may kindly see.
Any appointment to the post in question shall be subject to listments. Let them make, but it will be subject to listments. The appointee shall be informed of that in the very appointment order itself. What?
Item 17.
My lord, item 17 come with along with the double PC number 26645 on 2025. It is a similar matter.
The matter.
Similar.
What you have thought for?
Gradation list is under challenge.
Yes.
What is that you have challenged? For quashing, brother. For quashing, it should be writ of certiorari. Or you only say issue appropriately. You have said mandamus to quash. You can't give mandamus to me to quash. Is it not? Mandamus means direction.
Direction.
Certiorari means quashing some order, some record. That we should just see how many years you have practiced you have put in.
2 years.
2 years. There is one good book. There are many books. I'm putting one or two. Writ Jurisdiction by B.L. Hansard, published by Indian Law Institute. Okay. Law of Writs by B.G. Ramachandran. Read whenever possible. Now I'll issue notice, no problem. But you should upgrade yourself every day, 2 pages, 3 pages, 4 pages.
Yes.
Okay?
Yes.
That helps you. And you will be, after retirement, when I come for Jagannath Prabhu's darshan, you will be a senior advocate. What of it? It's not. Issue a notice. G accept notice for the office.
Item 18.
My lord, message regarding regularization of the service, your lordship's earlier order. My lord.
Have you given?
Yes, I have already.
Mr. G will say it is a subject matter is covered. Give foundational facts, brother. Identical.
I didn't.
Except date.
Accepted data and council for the state.
That SLP is rejected.
SLP is rejected. Sub item same.
Both are same, na?
Item 19.
Lordship, petition before your Lordship pray for part-time physical education instructor for regularization. Similar order, my lord, is passed.
What order?
Forward that copy to the state also. That Jago regularize in terms of Jago.
Jago.
Jago. One part I have
Jago and
corrected your
Jago.
12 years and corrected for 9 years.
Covered by judgment, Mr.
Obliged Lordship.
Item 20.
May I please, Your Lords? The petitioner was appointed as a clerk in high school, and he filed a granting case before the education tribunal, state education tribunal, for approval of his post by implementing one Rabindra Kumar as one of the parties. And the state education tribunal directed the state respondents to conduct an inquiry and unreveal the truth regarding appointment in question. Inquiry was made and inquiry report was given in my favor, and thereafter, my lord, inquiry
Where
report
is that inquiry report?
my lord, inquiry report is next, sir, my lord. Page 6 and page 37, annexure 6, my lord. Annexure 6, page 37,
57.
my lord. May I read, my lord?
Name of Sri Sahu is clear.
My lord, is petition.
Clear cut.
Evidence, which is in the inspection.
Then what happened?
Thereafter, my post was thereafter the inquiry report was submitted before the education tribunal in the educational proceeding, and education tribunal dropped the education case
On what now?
on the basis of the inquiry report. That is page 39, mile.
And now what happened?
Thereafter, my post was approved, mile. Annexure 9, page 41.
Yes, everything is in your favor. Why are you here?
After approval of my appointment, suddenly the district education officer cancelled my appointment on the wrong ground, approval on the wrong ground that education case is pending. But most prior to that, education case was disposed of. Lordship kindly see Annexure 10, page 42.
This is dated.
This is dated, my lord, 3/8/13.
Thereafter,
this was cancelled on the ground that, my lord, the execution case is cancelled pending a final outcome. Your lordship kindly see.
Then what happened? You have said that. Not further.
Thereafter, my lord, after cancellation, one Ravindra Kumar approval was made in favor of one Ravindra Kumar, and I challenged that appointment, and this honorable court allowed my writ petition and directed further inquiry, quashed the appointment, the approval, and directed for further inquiry. So for further inquiry is concerned, I challenged before the division bench in the writ appeal. So once inquiry has already been completed.
What happened to writ appeal?
Writ appeal is pending, but during pendency of the writ appeal, they are not, the school management is not allowing me to discharge my duties, which amounts to prevention of service. I approached the state education tribunal.
But your writ appeal is pending. You should have sought for a direction there only.
My lord, for allowing me, yes, for more allowing me, my lord, that is different cause of action, because whether inquiry should be made further or not further, that will be considered by the writ appellate court.
No, till that happens.
But so far as my duty is concerned, let them allow me to continue. Discharge my duty. That will be.
Question arises whether parallel proceeding is maintainable.
This is not parallel.
And the state education tribunal has rejected his application on the ground that writ application is pending. That is Annexure 18, page 30.
That is
on the ground, writ appeal is pending.
Writ appeal, my lord, is pending on the ground that, my lord, two parts. Judgment of the honorable single judge is two parts. The appointment approval was quashed and was my favor, and directed further inquiry.
That is against you.
That is further inquiry. My humble submission is that once inquiry was made on the basis of the direction of the education tribunal, and thereafter nobody challenged, and my post was approved. But the inquiry is not.
That is
that is separate cause of. So far as
you tell me the judges, I will also tell them. He came and argued like this. Kindly consider and dispose of the writ appeal. How can you maintain? You make appropriate application before the appellate court.
My lord, appellate court is a different cause of action. Your lordship, my humble submission, my lord.
No, suppose now inquiry is ordered. That you have put in challenge. The first part is in your favor. The second part is against you. Therefore, you are before the division.
My lord, right.
Then only you make an application. I will permit you to. Otherwise, I cannot maintain. You cannot maintain another writ petition.
Yes.
Not just
preventing, my lord, preventing duty, my lord. Not that preventing a duty which is amounts to
that you tell it to the division bench. Will permit you now. It may be different cause of action.
Purely
It has
different. Not
completely-
rightly held that it is different cause.
No.
Only I am not saying to give me salary, only to discharge my duty, to allow me to discharge my duty.
It is not very simple. Prayer appears to be very simple. It is like telling the God, only show me once, give darshan once. That itself will be sufficient.
And that in 2024 they are not allowing me to discharge my duty.
Not it is, because proceedings are pending. I agree with Mr. Lanka.
Lordship, keep the matter live.
Why I should keep it?
My lord, I will, so far this point is concerned, I will satisfy in the letter.
Is it? We have argued not much now.
The Lordship, one chance may be given.
Call after put this matter after petitioner's writ appeal number.
Writ appeal case 2304 of 2024.
2304 of 2024. Please dispose of final.
And it will take some
So it
time.
will take a longer time. Therefore, I told you, make an appropriate application. The judges may say, why application, brother? You argue the main matter itself. We hear. That helps you.
Supposing my lord, my humble submission, supposing my lord, order of the honorable single judge will be held valid. Whether they deprive me to discharge my duties,
Yes, the inquiry has to be completed.
earlier inquiry was made, my lord.
Correct. But now court has now
Directed for second inquiry.
court has ordered. It may not be correct. Arguably, I do not know. Why by your version? It appears to be in your favor. But that inquiry is ordered by the single judge. During pendency of the inquiry, how can you say that I should be given entry to that?
I was continuing, but 2024 they have not discharged my judgment allowed me. 24.
That happened when?
2024.
2024. My writ appeal is of which year?
It is 24, man.
Therefore, I said, there is nothing. The best way is, the best way to answer your client also. What I will do is, this prayer can be sought for by the petitioner at the hands of the division bench before whom writ appeal is pending. Half of learned single judge's order gone in his favor. Instead of keeping it pending, it only gives the statistical data. There are two words saying that one more case, unworthy case.
In the meantime, I have 3 years left for retirement.
All this you should say to the division bench. There is in division bench 2 judges, collective wisdom, more wise.
May I say?
In the meantime, my
permission to withdraw this writ appeal?
No, he cannot. He has to answer his client. Na? I'll take some order. Petitioner's prayer is as under. First, counsel for the petitioner vehemently argues that although he challenged to the direction of the learned single judge in WP number
10577 of 2015.
Right now, I cannot understand what you are saying.
10,000
ways when you are giving the number.
10,577 of 2015.
Right now.
Mine.
Petition prayer reads as under. Essentially, petitioner seeks an order for permitting to gain entry to the employer's premises during the pendency of the writ appeal number so and so.
I'm giving.
Wherein he has laid a challenge to a portion of learned single judge's order dated so and so, entered in WP number so and so, to the extent it directs further inquiry in the matter. Fresh inquiry or further inquiry?
After hearing of the matter.
That is further, that is fresh inquiry in the matter. First one. When this was pressed into service by learned CDA Mr. Lanka appearing for the OPs, counsel for the petitioner very vehemently submits that this case is founded on a new cause of action and therefore has to be heard independently of the report. Next one, having heard the learned counsel for the parties and having perused the petition papers, this court is broadly in agreement with the submission of Mr. Ka that petitioner can make an appropriate application in the pending writ appeal number so and so, and he need not have the apprehension that the hearing of that application would not be taken at the earliest point of time, regard being had to be urgency pleaded even before me, was ordered accordingly, and the petition is disposed.
Will also dispose of.
Yes.
Pending.
Nothing. No, you're wasting time of the court. Next.
Dispose.
Item 21.
Whether the petitioner to make appropriate application to the region wherein his writ appeal is sent. First, all contentions are kept on.
Let me take up 30685. This
30685.
first, my lords. So I come to page number 58, my lords.
58.
Yes, my lords. This is a dispute review expert commit that has been page 58 of the agreement, my lords. That is the
Give me the make the
yes, my lords. In the agreement, there is a dispute review.
Why are you here?
Yes, my lord. Because the dispute review expert body or recommendation has not been accepted, although the contract says that they cannot shy away from accepting the responsibility they are in without challenging the same. Now they have what they have done. The recommendations were there. They have not accepted them and said that we're not agreeing to it. The contract does not provide that. My so, my lords, may come to page 58 for a moment.
What was that contract about?
It is a worst contract, my lords. I was supposed, my lords, that the work was from the Paradip road, my lords. My lords, was that way, entire road from Cuttack to Paradip. 2 packages were there. This is the second package. I'll come to the first package. It's the first petition. Second package, my lords, what is the issue now, my lords? My lords, we come to page 15, the dispute review board clause. My lords, specifically, I'm reading out 24.1. If the contractor believes that a decision taken by the engineer was either outside the authority given to the engineer by the contract or the decision was wrongly taken, the decision shall be referred to the dispute review expert within 14 days. Now, let us procedure for disputes. The dispute reviewer shall give a decision in writing within 28 days of receipt of a notification of a dispute. The dispute review expert shall be paid daily at the rate specified in the contract data together with reimbursable expenses of the type specified in contract data, and the cost shall be divided equally between the employer and the contractor. Here is the most crucial point. The decision of the dispute review expert will be binding on the employer and the contractor. The contractor can accept payment and receive payment, can accept and receive payment after signing as in full and settlement of all claims. Number 3, if the contractor or the employer are not satisfied with the decision of the dispute review expert, the contractor or the employer are not barred from approaching the court applicable under courts applicable under the law. However, there will be no arbitration. So I don't have a dispute resolution clause pursuant to that. Only thing
yes, it should be. You should. I should process your statement now.
Yes, yes, Mr.
So arbitration is excluded.
Yes.
Now what happened?
Now, let me please come to page number 82 minutes. I have completed the work. Work is complete in all aspects. Page complete certificate is there on record. Now, page 82 minutes will see that there is a recommendation by the dispute review board appointed by the respondent.
Appointed by the respondent?
Yes. Now, let's see. He gives an opinion recommendation. Now, annexure 6 may be seen. Page 130.
130.
Yes, minutes. They call upon me that come and discuss what is the recommendation all about. 2 letters are there. Page 130, 131. At 132, Milords will see that I give my, what is the, actually what has happened in the, as per the DRE recommendation, what is the amounts, and I give them a rebate. I'm sorry, my lords, the rebate is at, yes, my lords, the rebate is at page 164.
You have given rebate.
Yes.
Then what?
Then, Mr. Messi, the page 170. This is on their instruction that you give us, go and give us what rebate you can give. I give another 2% rebate plus 1%. Now, my lords, page annexure 11. That my employer is the chief engineer. Secretary is the head of the department. Employer is the chief engineer. Any, my lords. This is what the chief engineer says. Plus the last 4 lines of para 1.
Page number?
Page number 173, my lords. Annexure 11. 2 rounds of negotiation meetings thereafter have been. Milos has it?
Thereafter have been conducted with the claimant on so
Yes.
and so in this office. Reduced their amount to rupees so and so.
So initially 34 crore, then I have reduced 31 crore. Now, my lords, kindly instruction may be passed whether to consider the negotiated amount to be released in favor of the claimant or for taking any alternate action to avoid legal complicacy in the matter. That's the next page. Yes.
Sorry, one second.
Yes, I'm sorry.
What is the pause?
Mirrors.
This is chief engineer road
to secretary under the government.
Chief engineer roads to
FA comes special secretary to government.
ER means what?
Engineer means engineer. It is a designation. Now, my lords, the last annexure, page 174. Last 4 lines. After careful consideration of the proposal, has been pleased to disagree with the recommendation of dispute review expert, as after examination found that the recommendation of the dispute review expert is without any merit. No reasons as to why it is without any merit. Contrary to the agreement.
Yes, Mr. Lanka, what is this all? There is some vyavahar is taking place.
Take instruction, your lordship.
Issue emergent notice. Mr. Lanka is requested to accept notice for
Proposal 1 and 2.
1 and 2, emergent notice to the rest.
No, not required. 3 and 4 are my JV partners.
But why did you implead them?
I will delete. I will not. Others will notice may go. They're not a problem. It is me only. I will receive. Yes, sir.
3 and 4.
Now it was the first one. The first one.
Yes.
Yes. What happened after the recommendation came? The DRA sought extension of time for passing recommendation that package. That has been denied because of this recommendation.
Oh, so it's a cat's shadow on the first one.
Yes, because of the recommendation of first one.
The same parties?
Yes.
Same on that. Yes. Call these matters to do that. Yes.
You're just fixing a date?
No.
Not.
I'm not.
Much. I'll mention much.
Item 42?
May I please, Lords? My Lord, this is a matter relating to appointment of under rehabilitation scheme. Lords, kindly see page 30, page annexure 6. In my name is find space at serial number 12 in draft list of appointment under rehabilitation scheme. When this list was pending before the authorities, my Lord, I filed a writ application.
Then what happened?
I filed a writ application before Lordship. The Lordship directed to consider my case. They have not considered. Then I filed a contempt application. That contempt application was disposed of with a direction to comply the order within 1 month. Thereafter, not complied within the specified time, then I file again contempt application. In that contempt application, this Hon'Ble Court directed to comply the order within 15 days, failing with the so amount of contempt will be issued. Thereafter, receipt of the contempt order, they have rejected my claim. Then I file again a writ application before this Hon'Ble Court. In that writ application, that was quashed, the rejection order, and directed to give appointment pursuant to the order of the Honorable Supreme Court in Moranand Sethi case. Thereafter, they are not complied with. I file a contempt application. In that contempt application also disposed of, comply the order within 3 months. Thereafter, they are not complied with. I file again contempt application. That contempt application was directed to issue notice, my lord. When the contempt application, when the notice was issued, they have filed a writ appeal against the order of the second writ application. That writ appeal also, my lord, disposed of with a direction in basing upon the batch of cases to consider the Bindu Sagar case. Thereafter, they have not complied the order. Again, they have to go to Hon'Ble Supreme Court. Supreme Court, my lord, directed to comply the order along with the batch cases. And thereafter, they issue, they have notified a notification, your lordship kindly see, page Annex 11.
Mr. Lanka, accept notice.
Yes.
It requires a lot many stories in this case.
In the meantime, what happened, I was small bear. In page 13, after the Honorable of the Supreme Court's order, they have issued the secretary issued a letter, 12% to appointment. You kindly see my page 68. There in my name is finds place at serial number 8. But they have the direct to the DO and as well as the director, my lord. They have not complied with, even if the recommendation was made and notice instructed to the appointment to me or the rehabilitation scheme, they have not appointed. And in the same list, 2 persons are appointed.
Juniors to you.
In that list.
In the list.
Yes, but ignore my case, my lord. That is Annex 13.
Let him take notice and come back. Well, short matter, just let him come back and then we'll make the order.
Because, my lord,
Can we make order without hearing it?
no, Lord, sir, they will also directly take appropriate step under Annex 13.
Application interim order.
No, Annex 13.
How can
Disclosure.
dispose of this matter?
In the light of Annex 13.
But that will not help him. How many cases he has got?
3 REIT applications, 6 contempt
I'm
applications.
telling you. Let notice go. Instead of directing the consider, that will never help.
Your lordship's permission, my lord. Your lordship issue notice about there is in direction that there is no bar to give an appointment or person to Annex 13.
Application.
No, my lord, that is the selection. That is
Issue about
13. So consider 13, my lord.
Where is your application for interim order?
No, I am not filing the interim
All
order.
right, next.
For consideration of Annex 13, my lord.
Next.
Item 23.
Both of cases are same, my lord.
Pendency of the petition shall not come in the way of consideration of representation dated.
I am not doing this. Recommendation.
Annex 13.
Annex 13.
At Annex 30. In both the cases 30.
No, the second case Annex 10.
10. Okay.
Well,
Emergent notice. Only government is the party.
yes, my lord, only comment.
Matter lies in a narrow compass. First off, it has got a checkered history, which arguably supports case of the petitioner. First off, therefore, pushed these matters, petitions, in the second week of December 25th. Next.
Item 23.
May I please, madam. On 30th of January 2025, my lord, petitioner was suspended, my lord. Petitioner, my lord, was working in a primary school teacher, placed under suspension.
Compassionate appointment.
No, my lord, I was placed under suspension on 30th of January 2025, my lord. No proceeding was initiated. I approached this honorable court. My lord, dispose of the writ petition, page 40, relying Ajay Chaudhary's judgment, my lord. In absence of any proceeding, I have to apply an application before the authority relying the judgment, and they have to pass order within 3 weeks, my lord. My lord, go page 40, my lord. My lord, got it?
Yes. Let him take.
No, in spite of complying the same, my lord, disposed of the petition on September 2025. I immediately submitted the order of this honorable court on 15th of September, my lord. Without complying the same, my lord, now what has happened? They issued a charge sheet way back of 5 months back, giving a back with a back date, my lord, Annex of 10, my lord. That is, my lord, my entire grievance, my lord. My reason for my submission, my lord, page 46, kindly see. The date which was given, 25 August 2025, page 46, and the memo, kindly see, my lord. The most important memo, page 48. Memo number 2052, dated 25/8/2025. Memo number 2. Copy to the headmaster HS Madhupur information request to hand over the copy of the draft charge of Mohan with proper acknowledgement. Where my headquarters was fixed, my lord. I applied him. You supply whether any document was received from the office of the opposite partner 4 with regard to charge. He intimated on the information, page 50.
No such record has been issued by the office of the DO and BO till date, my lord. Page 50, my lord. I applied under page 49. They intimated page 50. Another institution where they issued, they also intimated no such record was issued from the BO. Rather, being
Full stop at all to you.
sorry, sir.
Sorry. On contemplation, he was placed under suspension. Then now the charge, memorandum charges have been,
Articles of charge appear to be antedated.
that part we have come to take it. But here in the charge, memorandum charges, he has been asked to file his written statement. That's all. And he has been
Let
asked.
him file written statement.
Yes.
Let inquiry also go on, but the report shall not be acted upon without leave of the court.
Yes.
Issue emergent notice. First, that one AGA also notice for OC. First, the net counsel appearing for the petitioner cross attention of the court to IA number so and so, wherein the 6 IA is fine.
IA final.
6 interim protection against the ongoing inquiry. First, the content accused that the initiation of inquiry by the issuance of articles of charge appears to be is antedated, and therefore marred by one of First, there is some force in this submission. And the matter requires deeper consideration. First, next paragraph. Learned AGA Mr. Lenka very passionately submits that the inquiry in question need not be interdicted, and that the inquiry should be permitted to go on in a normal ways, of subject to the writer that the inquiry report shall not be acted upon till next date of hearing. Alright? Yes. This is fair. In the above circumstances, application having been favored, ordered accordingly.
Item 24.
You participate in the inquiry, but report shall not be acted upon.
Not for final decision without leave of.
That's fine. Even report shall not be acted upon. Yes. Inquiry without leave of report. Yes.
Transfer method, the petitioner has been transferred primary school teacher, my lord. The MLS interference, I have given the similar order, your lordship said.
Relieved or not relieved?
Not relieved, my lord.
Not relieved?
No. And apart from that, I am also a physical handicap lady, and my husband is also, my lord.
Follow along with WP. There are entry models.
My lord.
Entry models.
My lord. I have filed.
Yeah.
Corrected both the cases. I have corrected.
Thank God. Follow along with that. Other corrected matters do you have?
My lord, I have given.
Yes, sir.
2 orders I have given by correcting.
Yes.
Item 25 has been adjourned. Item 26.
This case, my lord, the petitioner had appealed test, and there is a provision for supply of the answer script for the perusal of the student concerned, the candidate concerned, and he has to file an objection. I have filed my objection on receipt of the application because I have corrected the application along with the evidence.
Patanaik.
Pardon me?
Patanaik. Where is Patanaik?
He is a government court. I was asking him, is it court number 12? He was there. I am coming from that court. Shall I be permitted to give a copy? I have to give a copy on the order of my lord.
This is a post notice or first time it has come?
It's first time.
Issue emergent notice.
No, it was on.
I said, that was an adjourn.
No notice was ordered.
No, sorry. No,
Direction was there to serve a copy to Mr. Yasan Patel.
That I have given. He is in court number 12. That is
These copies. We'll call it in the second week of December.
Not by the time, because already verification. She has been selected. This candidate has been selected, but her rank will be some changed, and she may get a appointment. Now she may not get the appointment. By these 4 questions, I have correctly answered. I have given this. This is paper of Sanskrit.
You last week call after lunch. I will inform Mr. Patna. He is also AGA.
No objections are filed. No, as a,
he has to file.
It requires objections.
10th or 11th, my lord, may fresh admission.
14th to it. To enable Mr. Patnaik to come and argue. In the meanwhile, objections counter filed. Yes.
Item 27.
My lord. My audible, my lord. I am in busy, my lord. My audible, my lord. My lord. As per the lawsuit direction, we sought the copy, my lord. Both state and the central government, my lord. As per previous direction, I have given supplied the copy to both the council.
You are for whom?
I am from central government.
Central government.
What instruction was called for?
Today I am appearing. I have no instruction.
You have no instruction. But the copy was served on which day?
Copy received on
1 month back.
1 month back. It has to walk from Delhi to.
I am assigned today only.
We do not know if there is delay, why he should suffer. You have been nominated only now.
My lord. Today night it is so. I prefer any other day.
ASG.
Any other day.
TGC. What is your designation?
CGC, Central Government Council.
The TGC should be showing so appear for the copy number 1 and seeks a short accommodation. First up, calling the second week of December. In the meanwhile, counters may be filed by the voters. Okay. Next.
Item 28.
28, my lord. This case has filed the same appeal. It was dismissed on default for non-production, non-filing of the certified copy of the order. There is a delay of 155 days. The lordship may issue notice on the delay, then
issue about that. Returnable within 3 weeks. Yeah.
Item 29.
29, this CMAPL is filed for restoration of the case because order passed by this Honorable Court was to produce the certified copy within stipulated date, which could not be produced. That,
dismissed.
That was dismissed by the registrar.
Registrar.
So, CMAPL I have filed.
Any delay is there, brother?
There was some delay.
Then notice has to go.
But it's state, only state is the party.
What is the number of days of delay?
Delay list.
Give our file only.
delay
557.
You have not filed IA?
IA for condonation of delay. Where you know, he has filed now?
In the first case I had filed, but after that...
in the second connected, you are not 2 and 3.
CMAPL, I have not filed because originally I filed the delay.
You file application. 2 weeks contains. At the request of counsel for the petitioner to file application seeking condonation of delay in CMAPL 249 of 25 and CMAPL 2.
Yes. The noting is there.
Yeah.
Noting is there in the list, my lord.
But copy has not shown.
IA 279, Lordships. IA 279 for condonation of delay.
279?
Lordship.
IA 79,
condonation of delay.
278, 279, 28.
Lordship.
Yeah, but at least give copy to the government.
No, you are not copy.
I'll give copy.
Or we'll conduct that today.
Let's see.
What kind of, for non-production of the document, dismissing the petition itself?
Before Lodgima Court, I think. Lodgima Court. It was the deputy registrar.
He has no option than to dismiss. We'll allow the application and we'll restore.
And dismiss is subject to your lordship's approval.
That's what. We'll recall that order. No, this is not happening to
Yes.
happen. These three CMA PL seek restoration of FAOs 271-23, 275-23, and 278-23 to the board. First, the petitions are accompanied by separate applications seeking condonation of delay brooked in moving the petitions. Go to application. Having perused the papers, IAS seeking condonation of delay that are supported by affidavits. I have considered views that delay should be condoned and the petition should be allowed, restoring the said petitions to the boards for consideration on merit.
Subject to production of the certificate copy.
We have filed certificate copy. Well, we have filed. That's why it
Yeah, you have filed also.
Let's certificate. That's why it has come.
Ordered accordingly. And petitions are what should happen now? Disposed of. And they should be restored.
Restored.
Petitions are disposed of, restoring the subject FAOs to the board for consideration. First, court has noted production of certified copy in order put in challenge in these FAOs. You have produced.
No.
It appears you have come from directly from some chowdhury, marriage chowdhury. In a few minutes, I'll come back.
That was I was expecting. What emanates from my lord's mouth, I was expecting a break.
In paragraph 3, your lordship directed me to serve to extra copy Mr. AGA to accept on behalf of 1 and 4. That is to be 3 and 4.
The order dated 19/8/2025, at para 3, mentions OP numbers 1 and 4 instead of 3 and 4.
Yes. And the second paragraph 4, that is 1 and 2.
Similarly, at paragraph 4, instead of OP numbers 1 and 4,
1 and 2.
1 and 2.
1 and 2. Copy for 1 and 2.
Instead of come on. Wrongly, OP numbers 2 and 3 are there. Registry to effect necessary correction.
My humble submission, 1 and 2 on behalf of Mr. S.C.
Mr. S.C.
I have received.
So appears for OP numbers 1 and 2.
1 and 2.
1 and 2. And
I will serve extra copy.
The counsel to serve
Copy mirror. 1 and 2.
on the document from the net counsel. And 3 and 4?
My learning senior also.
Mr. Lenka appears for copy number 381. Yes.
May I please? That this Hon'Ble Court please to stay my transfer order on 17th of this month. I have produced the certified copy of this order before the authority that is VO and DO on the 22nd of this month. In spite of the communication of the order, but the opposite has on 24/10 and a relief order has been. Therefore, you know, may I submit it? Therefore, I filed this IA. But in the meantime, yesterday, one letter issued to me, the cancellation of my transfer order.
Sometimes it happens.
Yes. Therefore, I used to withdraw this interim application.
One thing your lordship, I will point out your lordship may see your lordship's order last two lines.
The above circumstance, take coupled direction before immediately. If this interim order is not complied, the defense of the OPs may be struck off and their counsel may not be heard in the matter. Because of that, they have now.
But now that hasn't complied.
Because of the threat. Otherwise, we would not have permitted to say anything.
Yes.
The subject application in INO pursuing soul has become infectious. Since the authorities of realizing their mistake have complied with the interim order dated 17/8/2020. Yes. Petition is application is referred to this court.
Item 32.
Fix a date for fact.
You have interim orders now?
Yes, sir.
Yes.
Yes. I mean, members, 1 week time I've taken consent to members, of course, man, so the name of my to find a counter. Of course, counter may not be necessary.
One thing I tell you, I should learn humility from you. Yes,
Not that well.
Yes, sir.
I pray let them file counter so that let it
No matter. If my lord will be pleased to dispose it of, dispose it of.
Any counter is necessary.
May not be necessary, my lords. To me, my lords, may not be necessary.
But if the grievance, how grievance can be addressed?
May I submit, my lords, from his side or both sides, my lord?
Yes.
let it come next week.
Subject to rider that you should not seek share in the fee. Share in the fee.
I'm not going to say that.
I pray 1 week time, next week come next week, next Thursday. I will pray.
Is it?
Yes.
Next Thursday, difficulty. First week of December week.
Yes.
First week of December at the request of for the yes.
Item 33.
That's it. My lord, I'm extremely sorry, my lord. Just minutes before I got the Parawise comment, Lord may give me some time.
First week of December?
My lord, yes. Second week of December, your lordship may call.
Second week of
this
matter in second week of December at the request of Mr. G.
Last time also.
Who may file
meanwhile.
Generally, he will not seek time at all.
Just minutes before I have received.
Last time also.
Yes.
Item 34.
Reports, my lord, has counter also not filed in this case. Notice is
filed. Whether they may or may not file. We want to file counter or no counter is necessary?
Counter is necessary, but so far as impugned order is concerned, my lord, it is very clear. Impugned order annexure 5. If may I place, it's a small order, my lord.
I work for the third period.
Yes.
Yes,
Your lordship, page 14, your lordship may kindly have a look. Says
illegal, unwarranted, and violation. All superlatives have
There was no need. There was no need for appointment of the petitioner in so and so ME school Chandan Bazar during the period from 85 to 86, 90 to 91, as the roll strength of the school is as follows, and two regular assistant teachers were working in the school at that point of time. The yardstick is two teachers, my lord. They were working.
You will be third teacher.
You will be a third teacher. That is not permissible. 85, 86, 40.
Did he work with?
Yes, my lord. Next, last paragraph.
Petitioner
last word, second paragraph.
Yes, I'm placing that.
Yes.
I'm placing that.
Yes.
The petitioner, Sri S.K. Das, was not possessed any training qualification for the post of assistant teacher at the time of appointment, and any payment has not been made to the petitioner by the managing committee. That the petitioner, Sri Das, was appointed in different spells on 89 days basis from 1711 to 86 to 1691 against the suspension vacancy of Sri B.K. Samanta, the then headmaster of SSS Chandan Bazar School, who was under suspension at that point of time. In view of the above, the appointment of the petitioner made by the then managing committee is irregular, illegal, or unwarranted, violates the Orissa Education Act. Thus, the claim of
86 to 91,
my lord, 7/11/86 to 1/6/91.
1711.
Huh?
1711.
17/11/86
My lord.
to 1/6/91.
91.
That is, you have worked only on totally 89 days.
89 on basis.
89 days, that means less than 3 months.
Yes.
Stopgap arrangement.
Yes.
That was not there. Against one suspension of one headmaster. That was, he has regularly worked.
Well, you were engaged to fill up the vacancy because the incumbent was suspended.
Yes.
Where is the case for you?
But appointed by the managing committee.
Where is the question of appointment? Where is the post?
There is no
That
post
is a
at all.
post meant for a person who is already holding it.
Yes, madam.
It is only suspended.
That is the improved order size, my lord.
That's correct.
But I was working for the said period.
That makes no sense at all. Had you been engaged against said vacancy, I would have understood. The vacancy arising because of suspension is not a true vacancy at all.
Let him
It is a masked vacancy. What is to be filed? There is nothing. I am dismissing the petition.
The petitioner was worked for the said period. That is admittedly worked for the said period.
But what can be done? Can you accommodate him anywhere?
My lord, how can he be accommodated now?
Somewhere. How many schemes you have got? This scheme,
Schemes, he cannot be accommodated.
He is retired.
Retired from which place? From that school?
From other school.
Was regularized thereafter?
Yes.
Was he regularized?
Regularized, yes, my lord.
Where is that?
I am tested in my petition, but subsequently was regularized and retired as a regular teacher.
Is it?
That period not been considered. That's my prayer. That period has not been considered.
That period, how that period can be considered at least?
Mr. G, then he is right. The question is, he produces some material to show that his services are required and he retired from service.
Yes.
You produce that material. If subsequently, if his services are regularized, then you cannot exclude the period of service regular. There are such judgments from, I believe it is from Madras High Court. There is one such judgment in identical circumstances. Just look into that also. Further, you also look into that and that where is that regulation order?
By the miscus. By way of miscus, I will.
Next day you will produce it. Call in the. Do you have here with you the regulation order or some order to show that you were right?
At present, no.
Call in the first week of December 2025 to enable counsel for the petitioner to produce certain records to vouch that his services were regularized, and thereafter he demitted office on attaining the age of superannuation. Yes.
Item 35.
That matter, Lordship wanted me to take instruction why his services shall be regularized with effect from 2022 instead of from the date of judgment delivered by the Honorable Single Judge in this bench. Here, Lords, from his writ application, he was appointed as a Chowkidar cum watchman, Lords.
Appointed a Chowkidar.
Cum watchman, Lords.
Chowkidar cum watchman.
Yes. And in that organization, only one post of Chowkidar cum watchman is available, which was already manned by a person on regular basis.
So he was appointed on which date?
No, appointment is in 95.
Give the date.
Mayor, 22/9/1995.
22?
28/9/1995. Annexure 1.
28/9/1995.
Sir, last occasion, my lord, have directed it to corrected it without giving me regularization. They give me fresh appointment. The issue which has been settled by the Honorable Apex Court.
No, see that. Appointed on 28/9/1995.
Yes, Lord.
Did he have a requisite qualification?
Yes, ma'am.
Because
I'm asking a question.
Yes, Lord. Yes.
He is qualified.
Yes.
Was there any selection advertisement?
No. It's only contractual.
No, contractual are there. Even in advertisement selection also there may be
No,
contract.
there was no selection at all, Lord.
How long did he work?
He continued Silver's work thereon. Subsequently, he was even though he was appointed as a night watchman come Chowkidar, because that one post is available, he cannot be regularized. He was appointed on contractual basis as a peon, Milos.
Firstly,
yes, that is annexed of his documents, Milos, and some lordships.
Appointed. That happened when?
No, that is in 2007, Milos.
That is after 12 years of service.
Yes.
2002, sir. Annexure 2.
Annexure to 2002, Your Lordship, it's page 10.
Date 35/2002.
Yes. Post of peon. If the lordships get the order is, one thing may point out, the opposite party organization is a registered society body, Milos. Even though it's an organization of the under the state government, it has got its own rules and their own funds to regulate these affairs, Milos. So in 2002, he was appointed as a peon, Milos. We were allowed to continue as peon instead of night watchman on contractual basis, Milos. He continued there on, Milos. And thereafter, he approached this honorable court. This was directed to consider regulation, and thereafter direction was to consider his case for regulation within 3 months. We approached in writ appeal. In writ appeal, honorable court, this honorable court directed, there is no infirmity in the order, and we went up
Dismissed the appeal.
Yes, appeal, and so also it was confirmed by the
Dismissed the
Supreme Court.
appeal. SLP.
Now the question is, as per rules, Millers, one somebody who has to be appointed as a peon, he has to be minimum qualification of 10th pass, Millers.
No, how can I sit in appeal over the orders?
No. Why I am saying so? Because he was at that time, he was holding the post of peon, Millers, and he cannot be regularized, Millers, because there was only one post of when the person holding that post of regulation is retired, we regularize his services, Millers.
Where is the order directing regulation?
Sir, Annexure 8, page 23.
No, that is the office order.
That is, they have been given trace appointment.
Yes, I don't deny
without
that.
regularizing.
Where is the court order?
Court order is page 16.
Annexure 5, page 12.
WP?
Page 17. WPC 15725 of 2012.
No, whenever numbers are quoted, you should quote the numbers in such a way that the person who is listening to you is a matriculate paid candidate.
15725.
15725
of 2012.
Decided on
9/2/2016.
what is the operative portion of the order?
Sir, in page 17. In that view of the matter, since the petitioner is continuing in his post and has completed more than 20 years of service, and even though his appointment is irregular, he should be regularized in service in view of the judgment in the Apex Court.
Yes,
Ramadevi, Malkeshwari, and Kapil Hingorami, and judgment of this court in Binan Kumar Mahanti and others, accordingly, the opposite part number 2 and 3 are directed to regularize the service of the petitioner within a period of 3 months from the date of passing of this order. 9/2/2000.
There is there is an order for regulation, not considered for regulation.
No, not considered, son.
Direct
Direct order. But because there was no post of watchman available in the organization.
No, that contention you have taken before the court, only then this order is made. That amounts to asking me to go behind the order, which has attained finality at the level of the Apex Court.
Yes, no. That's why we regularize, Lords.
No.
We regularize because
Regularized in which? He went
watchman in the post who is eligible to be appointed, Lords. He was never
the order does not say that.
Because it says that watchman, Lords. Case is not peon. Case is only watchman.
Therefore, regularize when you create Trishanku Swarga and put him there.
Because
the court order.
I cannot create another because there is one post of watchman.
Wait, not. That contention you should have taken when you had laid a challenge in the division bench.
No, that we had raised that question.
You raised that question.
That question.
But then you cannot raise that question here.
No, that because in fact the honorable division bench, what they have said, the fact remains that respondents have been working continuously as watchmen. It is not the case of appellant that they are not qualified to be employed as watchmen.
Yeah.
That I admit also, Lords. Given the fact that the respondents have worked as watchmen on contract basis for over 10 years, it is obvious that the appellant requires their services. In the circumstances, the court is not inclined to interfere with the impugned order of the learned signature, requiring appellant to consider the case of responsible for regulation.
Yeah.
So, this division bench directed to consider the case for regulation, Lords. We went on to the Honorable Supreme Court. Lords. Supreme Court dismissed saying that there is no infirmity. So, when the post of watchman, regular post fell vacant, then we consider the regularized. Because division bench has said, consider this case for regulation. That is the submission.
Consider means it upheld the order of the EC.
Yes, Lord.
It does not say. It said in so many words, matter does not require interference.
Yes, Lord.
Therefore,
so consider that case for regulation, Lord.
Consider means as the learned single judge has said that way. It did not alter the order. It did not alter. That is not the case.
No, did not alter, but there is some variance.
One word is put there.
Exactly, Lord.
Because court did not interfere with the order of the
That is why, Lord, this order was passed, Lord, in 2020, Lord. Anyway, we went but that order was passed, Lord, on 16/12/2021.
6/12.
Sorry, 6/12/2021.
Who will take the judge along with you? What is the number of date of it?
2/31 of 2016.
Page 19, Lord.
Decided on
6/12/2021, Lord.
Now you have given him the peon post.
No. Same watchman, because he is not eligible to be appointed peon because he doesn't have the requisite qualification.
Now, how many days you took for implementation of the order?
After the Honorable Supreme Court rejected my order, SLP, we implemented the order of 2022.
SLP number?
SLP number, no, page 21, special 4893 of 2022.
Dismissed on?
That is on
17/5/2022.
The fresh order is issued on?
No, that is.
This is 28/2022.
Any interim stay at the heads of division bench? Or at the heads of...
That if the lordship can call for the records of the...
No, I will not look in.
No,
I cannot hold brief for your government pays me the salary, I will do it. Based upon your contention. No time will be granted.
No, I'm not seeking for time. I'm saying that here it can be seen.
No, I will not see that. If you want to see, you make use of our. I will not do all
Then your lordship may take it up after the recess. I will go through the
take down.
Or your lordship may permit whether there was an interim order.
Then you look into it and tell that. But I will not do anything. That's not my job. That's lawyer's job.
No, I wanted to do it, but some time, only 5 minutes time, because I have to go through the
other very only thing is every time arguing the matter and adjourning the matter.
No, I am not seeking adjournment. You also decide just 5 minutes to go through the records or orders of the writ of appeal.
Yes, sir. In the meanwhile, you just go through. I will be giving the dictation now. The earlier appointment was as Chowkidar.
Chowkidar come, if your lordship kindly look at it.
Is it a peon also?
Yes, my lord.
Now you are given fresh appointment as?
Watchman, my lord.
Watchman. My lord, kindly peruse the...
Watchman, any difference?
No difference, my lord.
No difference. Only thing is your grievance is it cannot be fresh appointment.
Fresh appointment.
Your lordship kindly look at.
My lord, kindly peruse the annexure 4, page 13. In 1996, the post has been created for the opposite part number 3, where my lord, the page 14, serial number 21 to 27.
Your nature of engagement is not altered.
Not altered.
You are treated as a fresh appointment. That cannot be your contention. When the first petition was disposed of on 9/2/2016.
16, sir.
Any time period was prescribed for
3 months.
3 months.
3 months from that date.
3 months you have to treat him as regular appointment. Take on. Kindly be seated.
Yes, sir. That I will go through the orders.
But still it makes no difference because ultimately he succeeded. You lost the case.
No,
so even if there is interim order, that fails into insignificance. I will assume that there was an interim order staying all this. But once you lose, you cannot take the benefit of interim order. It will go to him. That's the law. 1892. Queen's Bench.
But your only question is that there was no regular post of watchman available more than one.
Contention is rest dedicated. Kindly be seated. I will assume that there was an interim order. Yes. Kindly be seated. In the meanwhile, just give whatever records you want to look into. Just look. Yes. Go to the prayer for now. Sit down. Vasanto. Petition prayer is as under. First, essentially, petitioner seeks quashment of the order dated 20 August 2022, whereby he has been treated as a case of fresh appointment to the post in question. First, counsel submits that it was not a case of fresh appointment, but it was a case of regularization of his service, his client's service, pursuant to order dated 9/2/2016, entered by a coordinate bench of this court in WP number 15725 of 2012. First up. The coordinate judge had granted a period of 3 months for implementation. It was a clear-cut direction for regularization, as distinguished from a direction for consideration for regularization. First up. Counsel also submits that matter went in writ appeal number 331 of 2016. 231 of 2016 by the office, and the same was negative by the division bench from 6/12/2021. Lastly, OP's SLP number 4893 of 2022 also met the same fate at the hands of the apex court of the country, wide order dated 17/5/23. First, that being the position, he seeks indulgence of this court. Next paragraph. Learned panel counsel appearing for the opposing OPs vehemently resists the petition, contending that whatever be the arguable infirmity in the impugned order, interference of this court is not warranted, since broadly justice has been done by granting appointment order to him. First, he also highlights the word consider inwards employed by the division bench in its judgment dated 6/12/2021, and therefore the impugned order accords with the spirit of said order. Paid off. First, he also tells the court that the post itself was not available, and therefore the question of regularization cannot be treated in a normative way, fresh appointment having been issued to the petition. So contending, he seeks dismissal of the petition. Next one. Having heard the learned counsel for the parties and having perused the petition papers, this court is inclined to grant interference in the matter as under and for the following reasons. A, B, C, D. A. Petitioner, services of the petitioner were engaged as Chowkidar stroke workman with effect from 28 September 1995. After ascertaining his qualification, which satisfied the requirement. First, when his services were not regularized, he had filed the WP 15725 of 2012, which on contest came to be allowed by a learned coordinate judge of this court by order dated 9/2/2016. First, it is relevant to advert to the operative portion of the said order, which is as clear as Gangetic waters. They produce that operative portion. All right? Learned counsel for the petitioner is right in telling the court that it was not a case wherein the direction was for consideration for regularization, but the one where the OPs were mandamus to grant regularization within 3 months. First, next paragraph. The matter was carried in appeal by the OPs in writ appeal number 231 of 2016, and the same came to be dismissed on 6/12/2020. First, OPs being as relentless as can be, carried the matter further in SLP number 4893 of 2022, which met the same fate on 17/5/2022 at the hands of apex court of the country. First, it is only on August 2022 that the impugned order has been issued, that too treating the petitioner as having been freshly appointed to the post in question. First, that means his entire previous service is wiped out from the service record so that he would not be able to get any benefit thereof. First, this is unjust, arbitrary, and illegal, to say the least. First, the apex court in E.P. Royappa versus State of Tamil Nadu, AR 1974 AC 555, say that such an action is unsustainable in the teeth of Article 14 jurisprudence. But next paragraph. The vehement submission of learned panel counsel appearing for the OBs that the division bench order in their writ appeal 231 of 2016 altered the mandate of the learned single judge in as much as it employed the word consider in words, is bit difficult to countenance. In construing the court orders, common sense cannot be kept in cold storage. First off, a single word cannot change the spirit and tenor of judgments. First off, after all, a word is nothing but a skin of living thought, and it has no fixed contours of meaning. First off, the meaning of the word depends upon the company of other words by wide nossitude or socis. First off, therefore, the contention does not impress the court. Next paragraph. The vehement contention of learned panel counsel that they have issued the impugned order soon after the legal battle came to an end, victory having eluded them, is also not fully correct. First, the writ petition was decided on 9/2/2016, 9 February 2016, in favor of the petitioner. Writ appeal was dismissed by order dated 6/12/2021, and SLP was rejected on 17/5/2022. First, the single judge who decided the writ petition had prescribed only a period of 3 months. First, when the highest court of the country rejected the SLP, the OPs took more than 3 months to give effect to the order of the learned single judge. No explanation is offered whatsoever as to the brooding of delay, which borders a kind of showing scant respect to the court order, especially of those of the highest court of the country. That would not augur well to the good governance, to say the least. Next paragraph. In my considered view, this is a fit case where exemplary costs need to be levied on the OPs for taking the court order for a right. First, even the contention advanced before the court not only border the doctrine of res judicata, but unconscionability, and therefore the same unconscionability. Next paragraph. In the above circumstances, this petition succeeds. 7. A writ of certiorari issues quashing that part of the impugned order dated 20 August 2022, which treats petitioner as the fresh appointee. First off, the said order should be construed and read as being effective from the date the writ petition was decided on 9/2, that is 9/2/2016. First off, OPs to give effect to this order be rectifying the entries in the service records and all other records as well, and further granting all consequential benefits to the petitioner, treating him as having been regularized in service with effect from 9/2/2016 itself. First up, next paragraph. Which OP? Which OP has to OP number 3? Who is that?
That Vice Chancellor, Director of State.
OP number 3 shall pay to the petitioner a cost of ₹1 lakh within a period of 30 days. And this amount may be recovered from the erring officials, including the incumbent of the office of the vice chairman, incumbents of the office of vice chairman, during whose tenure this unhappy episode happened, and the amount shall not be charged on the public expenditure, stroke public fund. Yes.
Reconsider the cost part. Because there is no intention to harass him.
You have harassed him. Poor man he is. Now he should go.
Now you'll pursuant to lordship's order, he has got that benefit.
What benefit?
That from all benefits
you have taken him to the Delhi. Who should bear the expenditure?
No, he has not appeared on the Supreme Court.
All right, but you wanted him to appear. You pay 50,000 rupees. Make it 50,000. Yep. That should be paid within 30 days. Delay in payment shall carry ₹500 per day. In addition.
Item 36.
But this is a case of promotion from group D to group C, my lord.
Group D to group C.
Group C, my lord. And the petitioner is a senior person, my lord, and juniors have been promoted, my lord, to the post of to the cadre of a junior aspirant, my lord. So the petitioner, my lord, approached before this honorable court, my lord.
Juniors have been granted promotion.
Promotion, my lord.
They are granted promotion when?
Granted promotion, my lord, on 17/5/2023.
17/5/23. Who appears for the OPs? Mr. G. Why this is happening?
My lord, no counter is there, so I cannot.
And then you file counter within 2 weeks.
My lord, your lordship have granted me time. granted time on 21st August, your lordship not given me time.
But generally, when juniors are granted promotion, it's a torture to the seniors to work under them.
Yes.
Though it appears very simple.
No, it is not
that
simple. It is not simple, my lord.
Every day he will carry the tiffin bags to the office, but happily he will not eat it. Because he's senior, he being the senior, he's denied the position.
Yes.
Juniors have been of injuries.
Lordship, 2 weeks after your lordship may call this matter.
Call this matter. Reluctantly, a period of 2 weeks granted for filing the counter. Failing which, petition amendments would be taken with face value. May be taken with face value.
May I pray, my lord?
Yeah.
Fix a time, my lord.
23 matter, 24 matter.
Yes.
In the second week of December.
My lord.
Madam Minister.
May I please, your lordship? My lord, the matter was regarding non-payment of revised pension after release of promotion. And last time, in the last occasion, your lordship has directed to take instruction regarding the matter of discrimination.
He has brought something.
The same order which your lordship wanted me to take instruction. After having received instruction that it's a fact, I refrain from making any arguments, leaving on to your lordship to pass orders, taking the stand in the counter, because the intention was not to harass him. Only at the tail end, I would request your lordship not to be harsh upon my...
No, I am not harsh at all. I am not a butcher. I am a surgeon.
Surgeon.
Yes. And if you tell the surgeon, do not amputate the leg, you will suffer the whole entire body will suffer gangrene. Have you seen this order?
Yes, it was that order which he produced.
He has produced it. What will you do now?
That's a fact. It's a fact that it's an order. So I'll refrain from arguing in the case.
No, you will not. You argue.
No, I'll not. My conscience says that since this order has already been passed in a similarly placed person who is convicted, but here is a petitioner before your lordship who is not convicted. So on that score alone, I'll not argue with my lords.
Whether anybody from the university is seeing your performance. Your fitness is enormous. Appreciable. So he has been granted promotion.
No, this person has been granted,
though he was found, he was convicted
and they have gone on appeal.
Appeal allowed.
Appeal.
Appeal allowed or pending?
No, that is pending.
Still pending.
Yes.
You have given promotion to him.
Yes, my lords.
And against him, there is no criminal case.
No, against him, he has been acquitted in the vigilance proceedings.
Yeah.
But the university has taken a stand that since appeal is pending.
Whose appeal?
Appeal of the vigilance department in this Honorable High Court. I have taken that stand in the counter also. So that is why parade before lordship take my submissions and contentions noted in the counter. I leave it to your lordship.
No, Mr. Patnaik, I have great respect and admiration for you. The questioning is a pendency, criminal appeal is pending.
My lords, I have stated in my counter at page 4, the number I have also given.
My lord, it is pending since 2017.
2017. But the pendency of a criminal proceeding,
my lords,
is it a ground? It is your appeal. State's appeal. State's appeal. So once a person is acquitted of trial, he regains innocence.
Definitely.
He is not even an accused.
I bother.
It is not even in any outlines of criminal law, which was prescribed to us during our LLB course. He differentiates innocent man, accused, acquitted person, honorably acquitted person, and convicted person. And also persons who have secured acquittal But state has preferred the appeal, or the other side has preferred the appeal. He gives the 5 categories. So here is a person, he is more than innocent because the trial has ended in acquittal. To him, you are not given the promotion. One who has suffered conviction and he has put matter in appeal, to him you have given the promotion.
Yes, that's a fact.
My lord, they have given the promotion, but the financial benefits they have not given.
That's what.
Yes.
Once having given, you have given promotion to you.
Yes.
Given on which date?
They've given on 14th January 2024, but it was with retrospective effect from 15/12/2010.
15/12/2010.
My lord.
All pre-promotional benefits he has got.
What promotional benefits?
Pre-promotional benefits.
Pre-promotional?
Because in the meantime he has retired.
That's all right. But if 15/12/2010.
My lord.
Effective date.
My lord. That is in Annexure 4, page 21, my lord.
University is very, very discriminatory. Suppose if University of Madras was Shantabai, which my professor used to teach us so passionately, I can never forget that case. It's a matter relating to admission of a woman to a college in Udupi and college being affiliated to Madras University. There the Supreme Court said, university is not a state under Article 12. But that came to be reversed by the apex court in Ujjampai, the state of UP. Therefore, you cannot be discriminatory. How long the amount has been withheld?
Well, after this promotional aspect, simply basic will be revised. With increment, they will again go for a new fitment of the basic. And accordingly, the pension amount will be changed.
He will be benefited in the pension part if this is granted.
Not only pension, all other financial benefits or superannuation benefits.
Unless the order itself says that he is not entitled to any benefit and the challenge to the order fails. Now it has to succeed. I'll allow this pitch with costs.
Only what I was...
Why? University. University is an educational center where discrimination and other things should never happen.
No, what I was trying to place before Lordship, and then since in many cases your Lordship has found fault with the university and has imposed cost, that will be a kind of a lesson for them.
No, this lesson is not taught. It's a different lesson.
No.
There are matters related to regulation, etc.
Like if your Lordship recalls, the day before yesterday, your Lordship has passed an order as regards 1 lakh
university.
My lords, 1 lakh rupees cost, which I was arguing on behalf of the university. This definitely would give them a lesson that henceforth they will be very cautious in these.
At least the interest has to be paid.
In that case, your
interest has to be paid.
But your Lordship may not record my concession in the matter.
No, I know. You have argued there. Kindly be seated. Grievance of the petitioner is short and concrete. First of all, he is invoking the writ jurisdiction of this court for laying a challenge to the order dated 4/9/1/24, 4/1, what is the date?
4/1/24.
4/1/2024, which reads as under. First, learned counsel for the petitioner submits that although the promotion has been given to the next level, while order dated 14/11 by the impugned order, the financial benefits have been denied, notwithstanding that the effective date of promotion is 15/12/2000. Counsel submits that the salary and emoluments payable to an employee or his property, and therefore withholding them or denying them amounts to violation of Article 300 capital A of the Constitution of India. First, he also tells the court that another person, namely Mr. Ashok Kumar Mishra, who was convicted in a criminal case and whose criminal appeal is still pending, has been granted promotion with retrospective effect and accorded all consequential benefits. First, counsel Nimoti E.P. Vayappa for State of Tamil Nadu, 74 C, report 5, says that university is absolutely unjust and arbitrary and also discriminatory in its actions for the petitioner. Therefore, he seeks invalidation of that portion of the impugned order which denies him the financial benefits on the ground that vigilance case is pending after he having been found acquitted at the hands of the trial court. First, next, sir. Learned senior panel counsel appearing for the university in his usual vehemence resist the petition, contending that although petitioner was acquitted in the criminal case, the prosecution has preferred appeal and therefore there is continuation of the criminal case. First, when criminal case is thus pending, the university cannot be faltered in denying the benefits of promotion during its pendency. First, so far as discrimination is concerned, he makes some submission to the effect that many hands work in the university without knowing each other, and therefore such things are not uncommon. Next, having heard the learned counsel for the parties and having perused the petition paper, this court is inclined to grant indulgence in the matter for the following reasons. Next, 1. Petitioner has been granted promotion wide order dated 14/11/2024 with the retrospective effect from 15/12/2010 is apparent from the impugned order itself. But when retrospective promotion is granted, the employer only rectifies the mistake he has committed to the detriment of employee. And therefore, ordinarily, in such a case, the principle of no work, no pay is not invocable. First off, an argument to the contrary would amount to placing premium on illegality. First, mere pendency of criminal appeal, petitioner having been acquitted in the criminal trial cannot be a ground for denying the financial benefits of promotion in the absence of any rule to the contrary. Mr. Patnaik, any rule is there which says if the criminal case is pending, even if promotion is granted, benefit of promotion shall not be granted. If the financial benefits will not be granted.
To my knowledge, there is no such.
First off, no contra rule is brought to the notice of this court, even when clarification was sought upon. First, next paragraph. Petitioner was tried in a criminal case and acquitted. First, an acquittal ordinarily remove the clog on the innocence of citizen. First, merely because criminal appeal is filed, the clog is not revived. First off, appeal against conviction is one thing, and appeal against acquittal is another. First off, in the former, the guilt having been proved, the status of conviction continues, although it may be suspended in certain circumstances, as held by the apex court in Navjot Singh Sidhu versus Delhi administration, something like that. Take out the judgment. In the case of later, the complete innocence remains intact with the person against whom the appeal is filed after acquittal. First, be that as it may, no explanation is offered by the university as to why Ashok Kumar Mishra, who was convicted in a criminal case after a full-fledged trial, has been accorded promotion by the order dated 5/8/2022, that too with retrospective effect from 7/3/2020 and with all consequential benefits, merely because a criminal appeal is filed against conviction and sentence. First off, the action of the university is grossly violative of Article 14 of the Constitution of India, which prohibits arbitrary and discriminatory action, as has been discussed in right down there, Navjot Singh Sidhu, which is that citation. No citation. There is a citation. I have read that one. Give that citation. First, now avoid E.P. Roy Sopra. Okay. This is a fit case for levy of exemplary courts, since university has acted very unconscionably by its employees when it should have conducted itself as a model employer, while the Bhupendra Nath Hajarika versus State of Assam, 2030, SC something. Other what judgment in the recitation note there. All right. Next paragraph. The above circumstances, this petition succeeds. The impugned order extent it denies consequential benefits of promotion accorded with retrospective effect is set at naught. First, the writ of mandamus issues to the university. OP number?
1.
OP number 1. To compute and grant pay, compute and pay to the petitioner all financial benefits of retrospective promotion within a period of 8 weeks with the interest at the rate of 12% per annum. Per annum. One more sentence you have to add there. Cost is same before that. The apex court in Padmanabhan Nair versus State of Kerala. Which is that? 84-85 Supreme Court. Look into that. Has directed payment of interest on the delayed dispersal of monies to the public employees in the public sector. K.N. Padmanabha. No, not this. No, apex court. Padmanabhan Nair. Not this. Nair, N-A-I-R, not Iyer. This interest rate 12%. And if delay is proved, the university shall pay interest at the rate of 1% per mention, 2% per mention. First. Next paragraph. State of Kerala versus Padmanabhan Nair. Citation. AR 1990. No, brother. Not 1990. It's an old judgment. No, not this judgment. 1983 decision it is, but reported in 1985 or something like that. Can anybody find out?
That is AR 1985 356.
AR 1985 SC?
That is AR 1985. Page 356.
356. Can you tell me the date of decision? Well, I read somewhere it was 1983.
17 December.
17 December. What is the year? 84. 17 December 1984. The university shall pay a cost of rupees 50,000 to the petitioner within a period of
111.
1983 it is.
17/12/84.
No, this is
it is there. 17 December 1984, date of judgment. Padmanabhan Nair, State of Kerala versus Padmanabhan Nair.
Is it interest related Padmanabhan Nair or any other?
Yes, interest.
Same. Same judgment. AR 1985 SC 356. Okay. Cost of 50,000, which may be recovered from the erring officials. Erring officials.
What I had prayed before your lordship is as regards the cost and the interest part which your lordship has said, that's definitely to pay. But there's a cost part, your lordship may pay.
If you are sure that you will not file appeal, I will waive the cost. Because this matter is bound to go in appeal.
No, in all fitness of things, supposing.
No, if you assure that, I will not impose cost at all.
Assurance.
Otherwise, another 5 years it will be fought.
As per conscience, if I am
You ask your client because you are holding brief for a statutory authority, they may not agree. You just ask them. In the event they agree, file a memo that we will abide by this order and we will not challenge it. It's your right to challenge. If you assure, I will give up the cost. I will request him to say yes to my proposal. You can leave that memo with the court office if they agree. Otherwise, order remains.
So, because if I am asked about opinion by my clients, I'll say no, definitely. That.
You also not do that. Let us see. Because he's in the evening office, like retired.
I do realize because
he's bedridden, my lord, 74 years old. So
74 years old.
It's all on a humanitarian ground. So science, law, science, arguments, etc. That is why at the outset I said that I will not be arguing before your lordship.
Yes, you are more than fair. Within 30 days. No, within 45 days, because it's reduced to file a fee. You have copied me. Even any urgency.
Case admission notice has to go only.
Wait, let us see. Yes.
Item 38, my lord, please.
Yes.
Item 38.
This is cover matter, University DDC matter, Litton Pradhan versus State of Odisha. Senior was present before launch. He was also agreed.
Patanaik.
Pardon?
Patanaik appears.
No, Mahapatra, Zanand Mahapatra, senior advocate.
Ask them. Wait for that.
Yes,
please. Yes. Ask them. Pass over. No, he's not here. We'll have it in the first week of December.
Associates.
I am appearing for this is a cover matter, your lordship.
Covered by judgment.
Please.
Here. Both the sides submit that. Yes.
Item 39. 49.
Which is wrong?
May it please your lordship.
30.
39.
No.
39.
Now which is disposed of?
38.
38. Yes.
May it please your lordship. I appear for the petitioner. Lordship, in this matter, learned DSGI appears from the other side. The time was sought multiple times for a reply, but no reply has come, despite the last order, which was more than 1 year ago. Lordship will see that order of 25/11/2024. A counter affidavit direction was given.
Where is he?
He generally appears on VC, but
generally he comes from?
Yes.
I beg apologies, my lord. My lord, I am appealing for the Union of India. My lord, in this case, my lord, so we have not filed our counter yet, my lord. This matter was the earlier counsels, my lord, they are not in the panel right now. My lord, so we don't have the. Humbly pray, my lords, I need some more time to file.
But I request this. This is a matter, if when Lordship hears the matter, Lordship will see that the union is a necessary party. The essential dispute is that I am a patent holder whose patent came to be lapsed or seized due to certain inactions on part of the patent agent or the counsel that I had engaged. Now, because I cannot make them a party as private individuals to seek an extension of time, the Union of India has been made a formal party. I do not know what objection they can give because the entire transaction I'm talking about is inter se between the party and the advocate. So if Lordship permits me, I can argue this matter. It's a very short point.
No, but without counter.
I understand because
Patent matter.
Correct. It's
without any consequences.
Without any consequences on the state. Zero consequences. Now, if Lordship may permit, I will just give a brief note.
No, that's fine. But brother, why you are not filing? Why is central government?
Big apology. In this matter, Mr. B.K. Padhi has been he was handling the matter, and he is not more in the panel matters. And today, my lord, in the first time I am appearing in this case. I need some time, and I'll file my counter in the meanwhile.
This matter. May I only request this? I travel from Mumbai for this matter. After 2 weeks, if
you can argue from
it's better because of certain connectivity issues. Sometimes it becomes difficult.
See, our advocates, they are more advanced.
No, I actually appear, Lordship.
Yeah, no.
And I give this example also.
I am telling something else. Yes. Our advocates, even in Katak, they argue from they are so advanced.
In fact, I give this example before the Bombay lawyers. There, the difficulty is that though VC is available, it is not appreciated. And here, on the contrary, we are
performance will be low. Secondly, it is online, so it will be doubly low, so that central government and state government will lose their case. Anyway, I am not happy that ASG is again in DST again and again appearing.
I'm apologize, my lord. The concerned the concerned file is misplaced because earlier counsel is joined in another panel. So let me give some time. In the meantime, I constitute the file and I will appear with the court in physically and.
Generally, government advocates, ASGs, advocates appearing for the panel advocates appeaing for various bodies. If they are local people, they should come and argue before the court. Otherwise, injustice is
there is no alternative to appear physically and doing the case.
All our lawyers are here. Everybody appears in person. Yes, anyway, next time. But what happens is, you will say one thing, I will say another. What he says will not be known to you. What you say may be partly known to him and less known to me. How to do justice? It is only for strange people I can understand. Of course, you are also busy lawyer. That's another thing. But
yes. Let's me fix one week after.
In first week of December, we'll have this matter.
No difficult, but only my request would be as a last chance for them to file any of
Yes.
because it's been more than 100
I said, they will run to bring that.
And assure that what best can be done, we'll do.
I will put it on terms as heard learned counsel Shri appearing for the petitioner who has traveled all the way from Bombay to Cuttack to assist the court, which is appreciable. First, learned ASG is appearing online again today, and he seeks time for filing the counter again. First time, because there are orders where to file that. As a final chance, the OPs are granted a period of 4 weeks for filing the counter, failing which the petition averments will be taken with their face value, and that will be one of the grounds for levying heavy costs payable by officials of the central government. First off, this order is made by way of a warning. Okay. Next, call this matter on. 8. December. Hold on, some date from the calendar.
Third, second, any date on the first week. It starts from Monday. First starts from Monday. Any dates.
Some date is second of December. Very far.
No, 2nd of December. Right.
Do not come online.
I do, but this is a matter where I have to run Lordship through certain documents. Therefore, it's more convenient to appear.
It helps me also. Anyway, it's very good. Yes.
Item 40. I pray my lord 10 days time to file counter appeal. And for OP number 2, 3, and 4.
2, 3, and 4.
Yes, sir.
Earlier you had taken time to file.
No, this is fast time.
Go to the earlier orders. All this matter on 2nd of December 2025 with the request of learned professor appearing for the which OP?
OP number 2, 3, and 4.
OP numbers 2, 3, and 4. Who may file their counter within 3 weeks after serving a copy thereof on the other side and on the government AG appearing for OP number 1. Got the first up. If OP is not filed, the petition elements will be taken with their face value, and that may result into allowing of the petition also. Next. Item 41.
Item 41.
4 to 9. Mr. Summarily argue this matter. Please authorize immediately another two. Time is not adjusted.
This is a case where
you need a lordship permission.
%20 vacancies are kept
Yes.
reserved now.
But what has happened, my lord, against those 20% vacancies, my lord, they are enjoying promotion by an illegally constituted selection committee and enjoying promotion, my lord, from 2023.
One nazar nahi deja. Next time, you take the petition elements with face value. No idea. Which is that judgment? Which is that judgment? Which Supreme Court said if a counter is not filed, the court it is open to the court to act.
Here, my lord, petition complete.
Not asking on that. We have filed the objections now. Counter is filed. Then argue.
Mr. Summarily argue this matter.
I do not know whoever. I do not know names also. I don't keep track of names also. But
this matter even tomorrow. Tomorrow, this matter.
Tomorrow we have to on 14th on 2nd itself. 2nd of December, finally at the request of the Learned Counsel appearing for so.
Item 42.
42, my lord, yesterday we have received counter. Yesterday.
Column 3rd of December at the request of one for the petition.
That item 41, I have some other matters your lordship directed those matters to be tagged to it.
You tell 41. Call along with the number services.
The counter
Item 48.
May I please, your lordship?
You are for petition of minor.
My lord, this is a case.
Yeah.
My lord,
Your opponent is are they ready?
States.
My lord, not fully ready.
On 4th of December, you
But the school is running without a science teacher. That is the difficulty.
Call on the 2511. Really? At the request of the
25 system matches there. 24, 26 matches there.
24. Well, then you put it on 24.
24.
Yeah.
Item 44.
Yes, the order impugned is annexure 7, my lord. Page 41. Start from page 41. The house rent, my lord, as per the circular, my lord, this is the second one litigation, my lord. As per the circular, my lord, you can see the page 11, annexure 1, my lord. Those who are resigning, my lord.
Who is your opponent?
My lord. State, my lord. State. Also, they have filed down. My lord.
What is the prayer?
My prayer, I am entitled to get 8%, my lord, the house rent instead of 4%.
Revised house rent allowance.
My lord.
House rent allowance is regulated by any rule.
Well, that's for the as per circular, the government. That is Annexure 1, my lord.
Annexure 1.
My lord.
What it says?
Let's see, page 11.
This is dated 14/3/24.
My lord. Which my lord, brother? 3A, my lord. The rate of house rent allowance would be admissible shall be determined according to the place in which the headquarters of the government employee is located, my lord. However, a government employee is staying higher accommodation living in his own house within 8 kilometers of headquarters shall be eligible to draw house rent allowance.
House rent allowance.
Allowance, my lord. Lordship, prior to that, my lordship, first, my lord, the column number 2, my lord, column number 3, the present petitioner in the Jagatsinghpur district, my lord. Jagatsinghpur, the third line, the column number 3, the third line, the Jagatsinghpur. Jagatsinghpur, my lord.
Yes, you are.
And he is entitled to 8% of the basic pay, my lord. That is the right side column, my lord.
Correct.
My lord.
How much they have paid?
My lord.
They are paying at one.
Now they are getting 4%, my lord.
Why, brother?
My lord, I am, let's see 1 minute, my lord. I have given the entire document. They have rejected my claim, my lord. As per your lordship direction, my lord, I approached the authority, my lord. The authority rejected my application on the ground that my school is, I am a junior teacher, junior clerk, my lord. My place of posting, my lord, in the rural area. Rural area that is within, that is 6 kilometers from the headquarters. 6 kilometers from headquarters, my lord. Here the circular is.
After one sentence, you have to.
Sorry,
allow me to process.
Sorry, man.
Then you will have respect.
Sorry, man.
Otherwise, it will be oral dysentery.
Sorry, man.
I should not say these words, but every day I'm being tortured.
No.
Sorry. You tell our Registrar General to put an order for one cartload of commas, full stop, inverted commas, semicolons, etc. Wherever I want, I will put them here. Poor communication.
Sorry.
What you are saying, whether I have caught it, whether judge has received it, is he treating it? No ABCD of communication skills. Yes. Sir. Slowly you say that. And many youngsters will be looking at you. They will start like that. That's not the object. In fact, Bhagwan Rajneesh Osho says, pause is important part of the speech. Pause. It's very important. You say that your case is covered under the Annexure 1. Annexure 1 says 8%. You are being paid 4%. Because you are at item number 4, according to them. But according to you, you are at item number 3.
3A.
You in which district you are working?
Jagatsinghpur.
Jagatsinghpur. Since how long you have been working?
Working
same place.
Same place. The exact
many
years, man.
Yeah. You have been. You are being. This is dated 14/3/2024. Is it retrospective effect or prospective? Which prospective effect?
There is a prospective effect.
With prospective effect. So, in any way, your claim has to be from on or after 14/3/2024. Where is you are trying to show that you are trying less than what is payable? Any proof is produced? You say you are given 8%. 4%. You ought to have been given 8%. Now, to show that you are drawing only 4%, not 8%, where is the material?
That is
that's your case.
That is admitted. Perhaps my senior will agree that.
Yeah.
My lord. My lord, so we also rely on annexure 1. 3, the column number 3. District headquarters.
No, 1 second. We'll read the first paragraph. Concept upon implementation of revised scales of page 2017. The state government have been pleased to revise the house rent allowance in respect of government employing the revised scale of pay, that is ORST rules 2017. The following rate and the manner. If they are working in district headquarters,
my lord, and municipal area of this Jagatsinghpur is there, my lord.
Jagatsinghpur is a district headquarters.
Yes, my lord.
Is working under that?
No, my lord. He is working in a Gram Panchayat area. We have stated in our.
How many kilometers?
8 kilometers.
No, 6 kilometers, man.
6 kilometers, what he has given aerial distance.
By aeroplane, if you go, it will be.
No, that is the document provided by the R&B mail. That is on record mail. That I have annexed mail.
That is aerial.
That is I have annexed. Now you can see the page 19.
Page 19.
19 mail.
Who has given this?
But the given the DO mail, District Education Officer.
This is where 19. Annexure 19.
Page 19, man.
Page 19.
Page 19.
With reference to the above section, it is to inform you that the radial distance of Hon'Ble village to district headquarters is 6 kilometers.
Well, radial distance.
Which distance to be?
Road distance. And my lords, it is in a rural Gram Panchayat area. It is not in a municipal area. That clause 3 says, the lordship kindly see, district headquarters stroke municipalities of Balangir, Baleshwar, Bargarh, Bhadrak, Bhavanipatna, Barbil, Yashoda, and it includes
district headquarters
stroke
municipalities of
Hon'Ble, Talcher, Titlagad, it includes.
All these are municipalities.
My lord.
All are
my lords. Jagatsinghpur. If it is within the municipal area, then he is entitled to 8%. In other places, it is 4%. In our
4 kilometers, 8 kilometers, 10 kilometers.
My lord.
Do you mean to say that?
No, my lord.
No. If it is 4 kilometers.
And within the municipal area.
So only distance is not the factor.
No.
Distance, no. If he is in the municipal area, question of kilometers will not arise.
No, not arise.
Well, question of kilometers will arise.
My lords, yes, your lordship kindly see.
That is permission, my lord. 3A. For that reason, 3A, my lord.
For
3A, I, my lord. 3A.
Have further decided that house rent allowance should be admissible to the employee of the state government at the above rate specified to the following stipulations. Subject to the following stipulations. The rate at which the house rent government is shall be determined according to the place in which the headquarters of the government employee is located. However, it's an exception. A government employee staying in a hired accommodation, in his own house within 8 kilometers of his headquarters. His headquarters means what?
Where he is posted, my lord, that is his headquarters.
Shall be eligible to draw house rent allowance. 8 kilometers, that is the house.
My lord,
that distance.
That is not in dispute. He is entitled to house rent. Now question arises, what rate, my lord? The next one is important.
For urban
headquarters, a government employee staying
in accommodation, own house, either of 8 kilometers from headquarters, or the limits of urban local bodies, municipal corporation, municipality, shall be eligible to draw house rent allowance as per
admissible rate. Admissible rate is
the Gram Panchayat is not included.
Not included. Well, we have stated in our.
But what about one he is saying? However, a government employee staying in a head of shall be eligible to draw house rent allowance within 8 kilometers of his headquarters. What is the distance according to you?
That is, my lord, we have stated 8 kilometers.
8 kilometers.
My lord, is that entitlement we are not disputing.
No, rate.
Rate.
No, that rate depends upon the distance between his residence and the headquarters.
No, my lords, that depends only on the location of headquarters. If it is within the municipal area, headquarters is within municipal area.
No, where was the need for that clause then? That way to be the object.
My lord.
The table would have answered everything. The sentence begins, however is treated by rent and mortgage.
My lords, however, a government employee staying in a hired accommodation, living in his own house.
Wren and Martin, in their English grammar and usage, say where word however is used, it should be treated as an exception to the general rule. Otherwise, going by your version, this will be like a non-utilitarian part of that body, like spleen, etc. Human body, it is said the spleen is useless. No? Similarly, that will be useless. That will be rendered odious if we agree with your contention and disagree with him. Then this part will be useless. Generally, government does not do. Presumption is government does not do useless things.
My lord,
subject to many exceptions. Another thing.
Let us say, however, a government employee staying in a hired accommodation, living in his own house.
Affect what is treated, the word however.
Within 8 kilometers.
Surendra Malik on words and phrases. Take up that. Find out word however. Library for 1 crore. There is another book, L.C. Goyal, on words and phrases. Do you have that copy? You take up. Why that old copy that has been revised thrice after this? Brendan Martin writes that wherever word like however is used, it should be treated as an exception to general proposition. If we agree with you, then in which case it will be applicable?
My lords, here, clause 2, for urban headquarters, a government employee staying in a hired
A, B, C, D are spoken in the no problem.
No problem.
But this clause is by way of an exception because it begins with the word however. Means whatever we have said above, all right, but these people will be entitled to that one. There cannot be any other meaning. If we are to go by your version, the table would have been sufficient. There was no need for this sentence at all.
My lords, here, my lords, after A2, last para, my lords. For urban headquarters, a government employee staying in
accommodation. Either within a radius of 8 kilometers from headquarters or the limits of urban local body municipality, as per so shall be eligible to draw house rent allowance as per admissible rate. This will relate to which one?
My lords, what I understand, my lords, if headquarters is in municipal area and he stays within 8 kilometers, he is entitled to at the rate of 8%. For urban headquarters, that is meant for urban headquarters.
No. That sentence also read for urban headquarters.
My lord, here the headquarters is rural
headquarters. Employees staying in a higher accommodation within the own house, 8 kilometers of his headquarters.
My lord.
It fits into one.
My lords, one is for Bhubaneswar, Berhampur, two is for, it is different categories.
3A1.
My lord.
3A1. What you say is, while interpreting 3A1, A1, even 2 has to be kept in view. That's your contention. Otherwise, 2 will commit suicide. What is it?
Lordship's punishment, my lord. They have annexed the entire document.
One says, my lord, if government employee staying in a hired accommodation, living in his home within 8 kilometers of his headquarters, shall be entitled to house rent.
Correct.
He is entitled to house rent. His headquarters being in a rural area,
there is a judgment of Supreme Court also. This word, however, is used. It is treated as an exception to the rule. However, it can be broken into these functions to introduce a proviso or exception.
That is general and however is exception.
Of course. Like in standard English, however, is used to introduce an idea that is contrary to the preceding one. When used as a transitional device, it creates a logical break and signals a shift in the court's reasoning or the argument being presented. As an adverb of degree, in legal, however, can also be used to mean in whatever manner or to whatever extent. In this way, so. This is how the Wren and Martin, right? They have not referred to Wren and Martin, but this is how they have read it. But some difficulty here. I will have discussion with my senior brothers and come back. Or some experts in matter.
Lordship, a moment, my lord. The Lordship can see the page 21, my lord. The page 21. The district education agriculture officer is situated at Nuapada. If Lordship permit me, my senior and I also same district, my lord. My senior, he is known by knowing the Nuapada. Where is the Nuapada, my lord? The place, my lord. The agriculture office, district agriculture office is situated at Nuapada. That is far away from the district headquarters, my lord. They are also getting 8% house, and that I have annexed. Page 21, my lord. Page 21, please. That is a rural area also. The Gram Panchayat area.
Item number?
My lord? No. Page 21, my lord. Page 21 of the
seeing you. There are many numbers.
Many numbers. All are except few persons on that Lordship is the right side, my lord. Right side column, they are getting 8%.
13 to 20.
My lord.
Serial number 13 to 20.
13 to 20. Previous 1, 2, 3, 4, 5, 3, 4, 3. They are also getting 8%. Subsequently, my lord, the 13 to 18, they are also getting 8%. That is Nuapada also, Gram Panchayat area. Lordship can see the page 23 also. The Jila Parishad office, that is the Sora. That is also rural area, my lord. That is the Gram Panchayat. The headquarters, that is also Gram Panchayat, my lord. But they are also getting, some person they are also getting, my lord.
Where is that?
That I have not annexed. That document I have given, my lord.
It does not say anything.
No. It doesn't say anything, but that I have document I have annexed.
Not for. Yes. Wait, brother, I just have discussion. I just have discussion. You also just have discussion. He is drawing attention to page 21. Just look into it. Appears to be what he says appears to be true also. All right. I'll have discussion because we will have some repercussions, financial repercussions. For this matter, first on 2nd of December. Yes.
Item 46. Item 46.
Item 46.
Yeah.
I am instructed to appear in this case matter on behalf of university.
Use of mic also. Yeah.
I am instructed to appear on behalf of university. I pray time there.
This is a 25 matter. No objection, no counter is filed.
No, not appeared yet.
What's the number?
1 to 4. University. Jagannath Sanskrit University.
1 to 4.
1 to 4.
AGA objects for 5.
My lord.
No notice of issued this.
No, for all the cases, notice has been issued except first item.
Sub-item? First sub-item.
First item, I have already served copy to the government.
Who is the answering? University is the answering OP.
No, university as well as government.
What they have to answer?
They have not served copy.
I have already served
copy. I inquired.
Give one more copy.
I have served my copy. Received.
So if you do not give, then call this matter if copy.
No, my lord.
You should not think of the small things. Then he wants copy so that he can put his objections. Petitioner to serve copy of the petition along with all the documents and the AGA is to Tehran right now. And file acknowledgement in the registry. First time. If that is done, call this matter in the first week of December. In the meanwhile, it is open to the OPs.
1 to 4.
And OPs to file their counter if any. Feeling which petition government must be taken, may be taken with face value. And the prayer also may be granted.
Sub-item 1 man. First sub-item. Notice not yet received. Served.
Now you are appearing, na?
Yes.
You serve extra copy, please.
Extra copy you served now?
Not yet served, sir. You will serve.
Yes, on the panel.
Item 47.
47, my lord, sir. I prefer from time to file counters. We have not received.
I am continuing annexure to C 15.
Second week at the request of learned counsel, in the meanwhile, same sentence. This would be counter may be fine. Very big. The petitioner may be taken up with the face value and will also can be granted to the that may be granted to the yes.
Item 48.
Your Lordship, item number 48, the petitioner has died. Your Lordship, I pray for... Yes, Your Lordship. I pray for...
Steps.
No, Your Lordship.
So far, the issuance of legal heir certificate is concerned in the other day, my lord has directed. And in the meantime, they have prepared the same, they can receive. Of course, it
is ready?
Yes, ma'am.
Then take this and I will say that...
I can send a survey copy also, no issues.
Over. Subject the AGA.
Morning I have received right now.
Having supplied heirship. Okay, what is legal heir certificate?
Yes, ma'am.
Legal has been supplied a copy of legal heir certificate to counsel appearing for the petitioner. Rightly submits that the petition itself has become infectious. Next one. In the above circumstances, petition is disposed of accordingly. But if there is any grievance, it is open to the lords of the deceased petitioner to take up appropriate proceedings in accordance with law. In that direction, all contentions are kept.
Grateful.
Next, item 49.
Item 49, pay for one password.
Password?
Yes. On behalf of Mr. Dhanamapat.
Item 49, I am for the OP number 6.
Your OP number 6?
Yes, Your Lordship. I am the person against whom the transfer order has been passed and is seeking for implementation of the same. I pray that I may file a counter affidavit, Your Lordship, because there's certain serious disparate question of fact are there which needs to be answered.
What is the interim order?
My lords.
Any interim order was made?
No, Your Lordship. There's only an observation that pendency of the application shall not be a bar.
Come in the way of.
Yes, Your Lordship.
This is in respect of that sexual harassment in the working place that the committee.
In the second week of December, at the request of the panel counsel appearing for OP number.
I'm OP number 6 to private opposite party.
They are private opposite party.
OP number 6.
OP
6?
Yes, Your Lordship. I'm great.
Item 50.
In this case, my counter has been filed, but copy not been served on us, man.
Your copy answer?
Not sure, no.
Right now, sir. May I say, here my lord has specifically directed to release the benefit, non-release of that pensionary benefit from 2024, my lord. Here, my lord, we have filed the counter, but the main contention is there. Because of that upgradation of in this digital platform, we have to put certain things. He can appear also in Monday, Tuesday, any day. It can be done and he will be released with this salary.
It's not. I'm instructed to appear with me.
The grievance of the petitioner. Can you dispose of the petition with that?
Exactly. That is the sole contention.
The petition. If you do not do it,
obviously.
You can revise the petition with a memo.
I'll go down.
You go there. If they do not do, file an application for revival. I will recall that order. The short grievance of the petitioner is reflected in the prayer column, which reads as under. Next. Learned AGA Mr. Mohanty, in individual fairness, submits that the stage is set for granting relief to the petitioner, subject to he complying with certain procedural requirements.
Technical.
Procedural for technical requirement. Petitioner may be directed to appear before OP number.
The treasury officer, BO.
Before the OP number 3, district executive.
OP number 4.
OP number 4, block education officer. On any day of the coming week.
Because in the meantime, we have issued series of letters. He is not responding and refused. That we have filed in the counter also.
To accomplish the requirement. First off, with this proposal, petitioner is agreeable, provided that, subject to the condition that, in the event the relief is not granted, he should be permitted to revive the petition by moving an application. Next one. In our circumstances, petition will be pulled off. 7. Petitioner to appear before OP number 4 on Tuesday. Give that Tuesday date.
Tuesday is
which
is a holiday? 10th.
10th
will be fine
because 2025 at 11 a.m. First off, when he so appears, the OP number 4 shall treat him with due respect and fully cooperate in accomplishing the task so that the terminal benefits reach the right person. First. Compliance in substance within 4 weeks. 4 weeks. Within 4 weeks. Yes.
Item 51.
Yes.
I have appealed for the respondent.
Respondent. Appellant.
Appellant is state.
State the appellant. Yes. Start. 2016 matters. How many such matters we have? Yes, Mr. Monson, what is the point involved in the impugned order?
Your Lord, the impugned order.
2015. EIA case number 523.
Yes,
2020. What was that case, sir?
Well, the crux of the point is the present opposite party respondent, one Saudamin Behra, was appointed as a lecturer in the political science in the year 1997, 28/5/1997.
Who was appellant, respondent? Who is that?
The respondent.
Respondent.
Yes.
OP number?
Sole OP. Sole OP. And joined in service on 9/6/1997.
That is appointment order is 28/5.
28/5.
He reported for duty on
9/6. And so far the conditions is concerned, so far the postgraduate, he has to secure 51%, 55%, my lord. But she has secured 48%. In the 91 rules, it was 48. Subsequently, it was revised to 55% so far the post-graduation mark is concerned, which has been given effect to on 11/6/1997.
11/6. But he is appointed on 28/5.
But 9/6 joined.
Joining whatever the joining period it will
28/5/1997.
How that rule will be applicable then?
Only that is the crux of the point. So far the amendment part is concerned, which is given effect to from 11/6/1997.
The qualifications required of a candidate for appointment are to be adjudged.
Are they?
As on the date, the application, you call it advertisement, na?
Yes.
The last date of the advertisement, last date will be fixed for filing the application. All applications, the notification is issued. Last date for applying such and such date. The law, as on the last date, will govern the terms of employment. Then you have no case at all.
That is the crux of the point, madam. Because subsequently,
the rules enforcement. That amendment was
11/6/1997, madam.
What was the requirement?
Percentage of mark is 55% in post-graduation.
55% in post-graduation. 48%?
From 8/4/91 till 10/6/97. 8/4/1991 till 10/6/1997.
You are right. Matter lies in a narrow compass, perhaps narrower compass. First off, the question is whether the OP who was appointed as a lecturer while the appointment letter date is 28/5/97 had the requisite qualification for the post in question. First, learned IGA appearing for the appellant state submits that the rules were amended with effect from 11/6/9. The extant rules were amended.
The Odisha Education Service, our secondary branch.
Namely, Orissa
education service, higher secondary branch, bracket, method of recruitment and conditions of service.
The almost our 4 to my quarters. So long. Right.
91.
91. Were amended with the effect from 11/6/1997, prescribing 55% in the PG as the minimum requirement, and therefore the OP did not possess the requisite qualification. First, this aspect having not been properly appreciated by the educational tribunal, state educational tribunal, kindly be educational tribunal, sit down. There is an error apparent on the face of the record, warranting interference of this court. This is under 24C.
Yes, ma'am.
Under section 24C of Orissa Education Act 1969. First, next paragraph. Learned counsel appearing for the OP submits that the selection process having been accomplished, the appointment letter was issued on 28/5/1997, and accordingly, OP reported for duty on 9/6/1997. During the period between 8/4/1991 and 10/6/1997, the required qualification was 48% in PG, which his client had possessed, and whatever changes have been effected by way of amendments post issuance of appointment order, post selection followed by appointment, would not be applicable to the case at all. First, next, having heard learned counsel for the party and having perused the appeal papers, this court declines indulgence in the matter, broadly agreeing with the submission made on behalf of the OP. First, any standard book on service jurisprudence, like Justice Ramajoy's on services under the state, and Samaraditya Pal's law relating to public service, would show that the law applicable would be the one that was in operation as on the day the selection process began, if not the last date prescribed by the recruitment advertisement for making application and staking claim in recruitment process. First time. The decisions in this regard, yellow in the law reports. Next paragraph. In the above circumstances, a bill being unworthy of consideration is liable to be and accordingly dismissed. Yes.
Article 52.
Yeah.
I am for the respondent number 3.
Yeah.
Last order.
Lord, your Lordship may kindly see the last order. This is an interstate dispute between the petitioner or the appellant and the opposite party number 4. The appellant is not there.
He's not there. If appellant is there, is not there, I cannot treat the appeal on merits. Supreme Court said I can dismiss it for default, but I cannot treat it on merits at all. Instead of dismissing, we'll give him final chance. You also informed that the judge was not happy because this is an old matter.
Old matter.
And very reluctantly I had to.
And my learned friend is also appearing for the respondent number 4. I am respondent number 3.
You are hand in glove.
Hand in gloves.
All these matters in the second week of December 2025 to enable counsel for the appellant to come and argue. And first off, registry to inform telephonically the counsel appearing for the appellant come on of this order.
Well, I have a small prayer.
Yeah.
Your Lordship may kindly see the last order. Your Lordship directed
9/25.
Yes. Your Lordship directed for payment of current salary.
Well, that will also not pay.
But my instruction is that has not yet been implemented.
I have government is to.
But
I have taken the instruction before lunch, Miller. They are in process. In fact, it has not been paid. And in the meantime, it will
and
be
her appointment has already been approved. She is continuing in the college, but she is not getting a
time be given.
No, nothing has happened. We have given so much time to you. Nothing has happened. 22/9/2020 to 2025. More than a month is over.
It is in the process, my lord. May I pray for
how long time will continue?
This court with order dated 22/9/2025 had directed OP numbers 1 and 2 to pay the current salary of OP number 4 with effect from 1/5/2025, keeping open the claim for arrears preceding the period. First, Mr. Mohanty assures that one last chance may be given for reporting compliance. First, I agree. First, call this matter for at least for the payment of salary. I will call this next week itself.
Yes.
On 10th, I will call this.
17th. May I pray?
No, I am giving more days. I am calling it on 10th of which date you want? You choose.
The 10th of November. No, 17th May is pray.
17th, huh? 17th now. Wait, sir, because whenever he takes time, they have their own constraints.
Because he has taken the responsibility.
And as the other matters, we have immediately complied, taken the indolence.
And the officers start doubting them.
Yes.
That is also there. I know because I was a very long period, I was a government advocate, central government advocate. Yes, all these things, I have seen them. Yes.
Madam 53? Here, that is the case where it's squarely covered by the Lordship judgment. Coordinate bench judgment. The Lordship judgment I have given and given a copy to my learned friend also. Twice I have given. So just look to that judgment and it is squarely covered. The whole sole question for consideration is that 1/4/89 cut-off date, whether it applies to a college which has got concurrence and affiliation prior to 1/4/89 or the person concerned. Applying the judgment ratio decided in a case of Pasumidas by the Honorable Supreme Court, a coordinate bench of this Honorable Court has decided a matter on exactly the similar point that that is applicable to college. And the present petitioner's college is a college, very old college. Way back in 1976, the college got concurrence and affiliation in 1980.
Such before cut-off date, what has been done, that cannot be.
The concurrence and affiliation of the college. The college which has established and got concurrence and affiliation. Concurrence from the government, affiliation from the university. That is prior to 1/4/89. So therefore, they are entitled, the employees are entitled to get the UGC scale of pay. Here is a case where the petitioner was appointed way back in 84 in a college. That college got concurrence in 1969 and college got affiliation in 1976.
Government concurrence.
Yes.
Government concurrence dated.
That is, we have given a list of dates.
Yes.
The record. That is already the record. Just I'm reading it and I'll show the judgment.
At 53.
50 second item. Yes, yes, sir.
It's already there. Second sub item.
In second sub item.
If you remember 481-18.
Actually, you concurrency time. It's just
memorable against you. That's a Kassia photo.
Yes. Does he get the yes. In 1969, Andhapur College, Andhapur is a very old college in the state. In the district of Kanujab, got the concurrence for its class 3 wings. 76, Andhapur College, Andhapur in the district of Kanujab, being a category 1 college, having class 2 and class 3, got affiliation and received the direct payment in the year 1976. 83-84, in view of the prevalent yardstick prescribed by the state government in respect of the non-government aided colleges in the state, the governing body of the college in question decided to create additional post of lecturer in physics from the academic session 83-84 with effect from 1683. In 2012-84, the present petitioner having the required qualification was duly selected against the post of lecturer in physics by the then governing body after following due procedure of law, and accordingly joining report of the appellant was accepted. That is Annexure 1, page 38. The state government by resolution dated 6th October 89 decided to implement the scheme for revision of pay scales with effect from 1186 for the college teacher on the basis of the recommendation made by the Government of India from time to time. Then on 25-10-1991, the state government, while later dated 25-10-91, was pleased to approve the creation of different teaching posts, including the 4th post of lecturer in physics. That is Annexure 1 at page 36. Then 17-1-98, as and when no action was taken by the state respondent to approve the appointment to the appellant, along with the release of the grantee rate, the appellant finding no other alternative approached this honorable court in OJC number 6.
On what ground the tribunal says otherwise?
Because the post was approved subsequently after 1489.
Approval of post is irrelevant.
Yes, sir. But let us also look to the judgment. I've given to you also that judgment.
That is
Sasmita Mahat.
Then what about a catch?
Same.
It's beyond this, just below the mention memos. Below the mention. In second sub item. Below the mention memos. First उसका ऊपर for WPC number 1.
High Court judgment है तब Supreme Court.
On the spin side. Where is the point?
The point is this, very short judgment. I'm just reading.
This is serial number 1.
Page number 1.
Page number 1 of that judgment.
Maybe compilation में page mark for lots of convenience.
Sasmita Mahanti versus State of Odisha Higher Education.
2 matters are there.
2 judgments I have given. The first one is the judgment of the coordinate bench. Then the next one is the Supreme Court judgment, which has been relied upon in this judgment.
That is the 1998 3SCC.
Yes. That judgment has been relied upon by the coordinate bench. That I will place. That I also enclose. You also look to the judgment of the coordinate bench. Exactly the same point. Let's get it.
Yeah.
Sasmita Mahanti.
Yeah.
Yes. Para 3. Petitioner has filed the present writ application inter alia challenging the order dated 15/2018, so passed by the government opposite part number 1 under Annexure 6. By the said order, claim of the petitioner to get the benefit of UGC scale was rejected only on the ground that the petitioner since was brought under the fold of grantinate with effect from 13/11/90 in view of the decision in the case of State of Orissa and another versus Ashwini. That's 98, yes. It is a case of the petitioner that petitioner was appointed against the post of lecturer in political science by order of appointment issued on 22/1/87 by the governing body of Panchayat so-and-so college, in the district Cuttack. It is contended that service of the petition was approved by office order dated 12/1/93 after 1489 under Annexure 2 by holding the petitioner entitled to get the benefit of 1/3 grantinate with effect from 30/11/90 after 1489. However, it is contended that as per the decision in the case of Ashwini Kumar as cited supra, the consideration to be made with regard to whether prior to the cut-off date, the college in question has got the affiliation or not, and not the consideration whether the petitioner got the granting aid after the cut-off date. The view expressed by the Honorable Appeal Court in the case of Ashwini Kumar Das, para 13 of the judgment is produced. Para 13, I'm reading.
Last 5 lines in that paragraph.
Yes, last 5 lines. Colleges which have secured, yes. Colleges which have secured government concurrence or affiliation from the university after 1489, therefore cannot claim any right to the higher granting aid contrary to the policy as laid down by the state. The High Court was therefore not right in coming to the conclusion that note in paragraph 2(1) of the government resolution 611 missing reliance of the aforesaid decision that was found to by notification issued by the University on 3/7/84 under Annex 1. The college got affiliation in respect of degree wings with effect from the academic session 84-85. Since the petitioner was appointed against the post of lecturer in political science by the order of appointment issued on 22/1/87, the petitioner, in view of the decision in case of Ashwini Kumar Das, is eligible and entitled to get the benefit of UG scale. But by holding that the petitioner since has got the benefit of granting it after 1489, claim of the petitioner was rejected by the impugn order, which is not the view of the Honorable Appeal Court in case of Ashwini Kumar Das. It is accordingly contended that the impugn order is not sustainable in the eye of law. Mr. Tripathi, an additional government advocate on the other hand, submitted basing on the stand taken in the counter, is contended service of the petitioner was against the post of lecturer science was approved with effect on 30/11/90 by the order dated 12/1/93, so issued by OP number 2 under Annex 2. Petitioner having been extended with the benefit of granting it after 1489.
So it had already got the affiliation. Therefore,
that's it. That is exactly.
Lord, recently 2 days back we have got the instruction, but my learned senior is conversing. So for the Sasmita Manti, Ashwini Das and Kabir Charan Swami versus State of Odisha. This has been well taken care of. And in the meantime, another matter is also pending before the Honorable Apex Court. May I take the instruction and return back to apprise your lordship?
Every time, sir.
Recently,
but this
whether any against the state bench order, did you make any appeal?
Yes, ma'am. Yes, ma'am. There is a interim order also.
Okay.
That I will come back with the details.
Right. The request of lovely on this matter is
no, I am sure that because I was told also today's morning. Yes, this case. Because this case is concerned, they have not gone, sir. Rather, the Ashwini Das case is the fine.
Yes. Here, the same point. They have gone to Supreme Court, a batch of cases, 100 of cases. That is the stage there. 25.
There also, I was also counseled. Yes.
25 the district before the Honorable Supreme Court that has been adjourned to 4 weeks after. There they have got a stay, but the Honorable Supreme Court has said will not give you any further time because other will vacate the stay.
Sir, those cases are different. I was the counsel here also. So those cases are not the cases where the college was a +2 college.
That's degree college. I was doing that.
The other cases of
anyway, just you also get clarity. Yes, I will call this matter in the first week of December.
Yes.
First week of December, all this.
Hashtag of miss.
Any other date you want to tell us?
I also.
At the request of learned Mr. for this matter on the 3rd of December, 4th of December. How many cases? 4th of December.
Super, the coordinate judgment they have not gone. They have not challenged.
But
I'm already very bad.
That's all. But the judgment on which coordinate bench has placed reliance, that is put in challenge.
So, no, sir.
Supreme Court judgment.
No, sir. The Ashwini Das case judgment is the judgment of the Supreme Court, which has already attended the final.
98, 99.
Yes, sir. 98.
Yes, but the Das says matter is pending before the
case, it may not burn. So this case, the Ashwini Das judgment was relied upon and it was allowed. Against that order, they have gone to Supreme Court.
State has gone to the
100 of cases. Yes, there they got a stay order. We have tried to 25/9 only, September 25th. It was there, but the learned Advocate General was not there.
So we'll call this matter in on 4th of December.
4th of December.
Yeah. Whichever date.
Your Lordship, because I was thinking that the man has retired in the meantime. He's in a difficulty. Can it be a little bit early? So that I can also take the party that case.
19th of Mr. Monty. Can you have it on 19th?
It's a matter.
A few matters. First day. That will be.
This is also a few matter.
14th. 21st. This is also a FA voting, na?
Yes, yes.
That is, we call this matter on 20th.
Yes,
matters
yes,
yes.
yes.
4 matters. Post this matter that day.
Okay.
20th.
Yeah, 20th.
Yes.
5th November.
11.
Please, Your Lordship.
Yes.
My Lord, I have already given the date chart. It is on record of Your Lordship. Yes, I have given. My Lord, I have challenged the judgment of the Learned State Education Tribunal dated 4th May 2018 in G.I. Krishna 522 of 2013 under Annexure 5, which is completely forwards and completely misconceived on the position of law, my Lord.
What was your grievance before the tribunal?
Tribunal, my claim was that I am holding the first post of lecturer in Odia in Gope Degree College.
What is meant by first post, second post?
My Lord, that in Degree College, my Lord, the compulsory Odia, the MIL Odia post is there. And another is the optional Odia. If workload is there, then optional second post is the optional subjects for optional subject, that is Odia second post for a lecturer. There are MIL is also taken as an optional in the degree stage, my Lord. While compulsory ODI is compulsory up to degree stage, my Lord. +2, then +3, my Lord. ODI is a compulsory subject in the arts stream, my Lord. Here what happened? The Gope College was opened with the +2, my Lord, in the year 1988-1. +2 only, +2 arts. There, my Lord, the college was notified as an aided educational institution with effect from 1/6/1985, my Lord.
IA stream means what?
Pardon, my Lord?
IA stream.
IA means +2, my Lord. Intermediate of arts.
Humanities stream.
No, intermediate of arts, my Lord. That now it became +2, my Lord. +2 arts. Then, my Lord, this college, my Lord, +2 IS college became added one with effect from 1/6/1985, my Lord. For compulsory subject Odia, one Gitabali Sorangi was approved against that post of for compulsory, my Lord. Then the second post became admissible on 1/6/1988, 1/3/1988. And another portion, Sarat Chandra Barik, was approved, my Lord. For first two, my Lord, 2 lectures were already approved, my Lord. That part is over, my Lord, up to 1/3/1988. At that time, that was a composite college, my Lord. The degree course was opened in the year 1918. When my degree course was opened in 1989, it got the concurrence appellation from the university as well as from the government from the year 1989. There, in the degree stream, my Lord, that one compulsory subject, Odia, was opened, my Lord. It is mandatory, my Lord. This petition was appointed against that compulsory subject lecture in Odia, degree stream, my Lord.
That is a third post.
Third post, my Lord. I was appointed in third post, my Lord. When the degree college was notified as an aided educational institution with effect from 1/6/1994, my Lord. In the granted in 1994, it was, my Lord, notified that degree college shall be treated as a separate college, my Lord. That is, I am taking to my Lordship kindly granting order 1994, my Lord.
It will be treated as a separate institution.
Separate college, my lord.
Now, how that is relevant for us?
For us, my lord, there the two posts, my lord, already approved, 2 persons were approved as lecturer in Odia in plus 2 wing, my lord. Now, when it became
That is Barik and Sarangi.
Sarangi, my lord, one Gitawali Sarangi and Sarachandra Barik. When my this 1694, the degree wing became added one, my lord, notified as added educational institution. I was holding the post of first post in Odia in respect of compulsory subject. Therefore, my service should be approved against the post of lecturer in Odia compulsory as per the granting order 1994, my lord. I will take to that statutory provision, my lord.
Yes.
Well, they did not do it, my lord. Then they approved my service as per the granting order 2009 from 2010 with effect of 2009, my lord. I challenged that before the tribunal. Now tribunal held that no, you have not hold the tribunal did not say about the first post. Who is holding the first post in degree college? Tribunal without any basis held that I am holding the second post. I am entitled to granting it as per the granting order 1994 with effect from 1/6/1993. That 1/3, 2/3 after 2 years and full cost after 2 years, my lord, after 4 years from the date of receiving the granting it. According to that, the Learned Tribunal, that post became entitled to granting it in the year 1998. That was dealt with in respect of my lord optional subject, not in respect of compulsory subject.
Yeah.
Then I am taking to your losses to that relevant portion of the judgment. Your losses kindly come to page 26, my lord.
Your opponent is government. Government is your opponent.
Yes, government is my opponent.
Government and for management.
No, management is not the opponent. It is the approving authority of the government, not management.
Government, the management supported your case.
So management has not appeared, my lord. That management has not
entered appearance.
Did not enter appearance.
And name is there, no?
What is the
name is there? It's a party, but you are not appeared. Nobody has appeared for my lord,
what is the question of law you are framing? Just
my lord, you will also kindly see 5 to 8 of the granting order 1995, 545 page. This book, 545. I am taking to losses to the relevant proposition of law. I-45 is the Odisha non-government colleges, junior colleges and higher secondary schools granting an order 1994, my lord. The plus 2 is treated as junior college, my lord. Your losses kindly come to rule 5, my lord.
But 94 is repealed now.
Now repealed, my lord.
But at that time it was available.
Available. It was repealed on 1/2004, my lord. Your losses kindly come to this Gopur Degree College is a category 2 college. Your losses kindly come to rule 4, my lord, at page 547.
Rule 4?
4. Categorized college, categorized as category 1, category 2, and category 3, my lord.
Yeah.
My college is category 2 college, my lord. I am placing that only. Colleges imparting instructions in presenting regular candidates for BA, BSc, or BCom exemption with or without honors of any of the universities which have been functioning regularly for 5 years or more by the 1st June 1994. After obtaining the government concurrence, recognition, affiliation of any university or for 3 years or more, if such institution is located in an educationally backward district which was not been notified as an aided educational institution and has not received granted from government for any post, my lord. My college is situated not in the backward district, my lord. Backward. It is in the Puri district, my lord.
So this is not applicable.
Only it is applicable, 5 years is applicable. Therefore, this institution was functioning from 1989, getting that concurrence recognition. Therefore, 5 years has been completed on 1/6/94. Therefore, this institution was notified as an aided educational institution, my lord. Then, my lord, your losses can come to 5 to rule 5, my lord.
No, you say B category 2.
Yes, my lord.
Which you have read now.
Yes.
What does it say?
It says that colleges imparting instructions in the present regular candidates in respect to BA and graduation, my lord. BA, BSc become exemption with or without honors of any university which have been functioning regularly for 5 years or more by the 1st June 1994, my lord. That is eligible for granted in the forward educationally well educated district, my lord. In respect to backward educational district, my lord, it is for 3 years, my lord. Then your losses can come to Rule 5, my lord.
All non-government educational institutions.
Yes, my lord. 5. The Rule 2A, my lord.
2 capital A.
A.
An institution being a
An institution being a non-government educational institution falling within category 2 has been functioning on a regular basis after receiving recognition from the government, affiliation from the concerned university or the council as the case may be for 5 years or more or for 3 years or more if such educational institution is located an educational backward district for prior to 1st day of June 1994. This is
for 3 years more.
That is the educational backward district, my lord. For general district, it is 5 years.
5 years.
Your losses can come to the note. An educational institution conducting BA, BSc or BCom degree college courses, junior colleges or higher secondary courses shall for the purpose of this para be treated as two separate institutions. Therefore, my lord, this institution, degree wing of the Gov College is treated as a separate institution as per this statutory provision, my lord.
BA, BSc or BCom degree courses and junior colleges shall for purposes of this para be treated as two separate institutions.
Well, therefore, granted now it is a separate institution.
No, for the purpose of this paragraph.
This paragraph for granted, my lord. It is for only purpose of granted to disburse the granted. My college was this degree wing was notified as aided educational institute with effect from 1/6/1994. That is an admitted case, my lord, by the government. And my lord, I was appointed, if it is a separate college, my lord, I was appointed against the compulsory subject of Odia as a lecturer in degree wing. When degree course was opened.
See, Sarangi occupied one post.
One post.
And Parikh occupied another post.
That is for plastering. When plastering, at that time, my lord, degree course was not open yet. Not there.
So in the degree course, there also Oriya is compulsory.
Oriya is compulsory.
Compulsory. In the
as per the workload, my lord, 2 posts were the college was entitled to 2 posts in plastering. Therefore, they were approved, my lord. At that time, degree course was not at all there. Now, my lord, your losses kindly come to Rule 9.
Rule 9?
Yes. At page 553, my lord. My lord, Rule 9, B clause, capital B, Roman 2, my lord. A post in a non-government educational institution coming under category 2, my lord. My college is coming under category 2 because it was, my lord, continued for 5 years as on 1/6/1994. And it is a category and it was imparting degree course and has not received the granted as on 1/6/94. Therefore, it is a category 2 college, my lord. There, my lord.
9(2)B Roman 1.
Roman 2.
Roman 2.
2, my lord. B Roman 2.
B2. Okay.
A post in a non-government educational institution coming under category 2. My lord. The post was admissible as per the workload and asterisk prescribed in this order by the Annexure 3, my lord. By the Annexure 3 is important for receiving the granted. The losses can come to page 581, my lord. Annexure 3 is there. 581. Annexure 3.
All right.
My lord, asterisk, do you also get it, my lord?
Yes.
Annexure 3, asterisk for approval of post in aided education institution for the purpose of granting order. Maximum number of subjects other than compulsory subject in which the admissible post of teachers will be eligible for approval purposes of granting it shall be as indicated in the table below, my lord. My lord, this table, first table is junior colleges, so we are not concerned with that, my lord. Only my lord, second, next page, degree college arts. My lord, my degree college, 128 student strength. 4 optional subject is admissible, my lord. And ODI is one of the optional subject, my lord. But I am not concerned with the optional subject. I am concerned with the compulsory subject. Your lordship kindly come to 2 plus 2. 1 post of lecturer for each compulsory subject will be admissible unless more posts are justified on the basis of asterisk of workload and on the basis of asterisk herein provided, my lord. Therefore, for compulsory subject, 1 post is admissible. This is mandatory, my lord. Even ODI subject is an optional subject in the college, that is separate, it is admissible on the basis of workload, my lord. I am not concerned with that at all. As I am holding the first post of lecturer, my lord, in respect of compulsory subject, my post shall be with effect from 1/6/1994. I am entitled to receive the granted 1/3 from 1/6/1994, 2/3 1/6/1996, and my lord, full cost with effect from 1/6/1998, my lord. That is my case only, my lord. But what the Education Tribunal held.
Your institution is treated as a separate institution.
It is separate as per statute.
On that there is no dispute.
There is no dispute. No.
Why tribunal denied relief on what?
Your lordship kindly. Tribunal without any basis held that I am holding the second post in the degree college, my lord.
It is first post only.
I am first post only. That is the error on record, my lord.
Which otherwise would have been the third post.
Yes.
Because of being deemed to be a separate institution,
yes,
it becomes the first post.
First post.
So, Sarangi, first post. Parikh, second post.
I am holding
in that institution.
Yes, I am holding.
Yours should have been third, but it becomes first post because it is a separate institution.
Separate institution, my lord. I am holding the compulsory post. I am placing, my lord, before your lordship taking to the judgment, I am taking to your lordship that the submission, the document submitted by the principal of the college under Annexure 3 at page.
Supporting your view.
Yes, my 20. Your lordship, I will come to page 20, my Annexure 3, my. First post that is plus two vacant data, that vacant mail is not applicable. My lord, this third plus 3, Balakrishna Swai, lecture in ODI stream. Balakrishna Swai is the present petition. The holding the first post, and Josna Mai Das was holding the second post in degree post. Then your lordship can come to the judgment. Well, what has been error has been, your lordship can come to page 26, paragraph 5 of the judgment.
This actually entire Keshavananda Bharati case is like this case. Yes.
My lord, I am placing paragraph 5, my lord. From the record, it appears that the applicant was appointed on 10/9 as a lecturer in ODI. I get third post. What do your lordship tell?
No, I have understood the facts now. Go to the exact point where the tribunal, according to you,
yes. Error, my lord, this is paragraph 5, my lord, paragraph 5, that is the error which has been committed, my lord, for which the judgment was completely illegal, my lord. From the record, it appears that the applicant was appointed on 10/8/1989 as a lecturer in ODI against third post and joined in service on 28/8/1989. That has been admitted, my lord, that is admitted case, my lord. On the date of appointment, the asterisk of the year 1983 was enforced As per the said article, third post of lecturer was admissible when the total classes per week exceeds 56. From the workload statement, it appears that total classes per week in the ODI did not exceed 56 till academic year 1991. It is not applicable when the statute provided that it became a separate issue. If it was a composite college, my lord, that is applied. That will applicable. It is not a composite. There the error was committed by the learned tribunal, my lord.
First error is
the workload, they applied the workload regarding admissibility of the third post, my lord. Once it became a separate college, my lord, for the purpose of releasing granted, then you will also kindly, I am placing again. From the workload statement, it appears total classes as per week of ODI did not exceed 56 till academic session 1991. Well, that is not applicable at all. Then, however, in the academic session 1991-92, the post was admissible. Therefore, even though the applicant was appointed on 10/8/1989 and joined in service on 28/8/1989, his joining shall be counted with effect from 1/6/91. First and second post of lecturer ODI were in receipt of granted prior to the commencement of the Amendment Act 1994, my lord. That was not taken into consideration, that the granted note was not taken into consideration. After bifurcation of the college, the applicant has been adjusted against the second post in the degree college. That is completely
adjusted against the first post.
First post only. I am holding the first post. Degree college. From the record, it does not appear whether lecturer was in receipt of granted prior to commencement of Amendment Act 1994 has been adjusted against the first post in the degree college or not. The degree college is a category 2 type of college. It has been admitted, it is a category 2 type of college, my lord. This is the error committed by the learned tribunal here, my lord. Because once it become a separate college, my lord, and I am entitled, the degree wing was notified, it has been notified as an added registration issue with effect from 1/6/1994, my lord. Then I am holding the first post only. There is no question of second post, my lord. Then your losses can come to the relevant portion.
Why Bible says second post?
I don't know that is without a post. Third post.
Even otherwise it would have been a
third post. It is a third post.
Mr. Monty, why tribunal is saying second post? Even otherwise, it would have been a third post. Because
one, two is there, other is
Sarangi and Barik plus petitioner. Even if it is considered to be one unit, that would have been the third post.
After bifurcation.
Yes.
After bifurcation, it becomes first. There is something in what learned senior advocate is saying. Tribunal slipped into error somewhere. Maybe because it...
neither taken into facts into account, nor the law, my lord. Both have not been taken. Then you will also kindly come to paragraph.
Subsequently, this same has been answered.
Why is tribunal is saying second post, I am not able to understand.
Yes.
And if that is cracked, I think I will be able to go through that one.
Then your losses can come para 8, my lord. The
first post of lecture.
The past post lecture in ODI in degree college was admissible, taking into consideration of the workload in MLO, the ODI, the compulsory subject. The second post lecture was admissible account of the workload of the both the compulsory and the optional subject, what I submitted before your lordship, my lord.
Now he answers that, kindly say that. Therefore, though the initial appointment of the applicant was made against the third post,
yes,
before bifurcation,
for an account of the workload of both the higher secondary course and the degree course and after bifurcation, the adjustment of the applicant having been made in the degree college against the second.
And the second, but that is without any basis.
That is without any basis.
Second post of the applicant became admissible to the college from the academic session 98-99.
If I had been holding the second post, that is.
He is holding first post. At the most,
after bifurcation,
most going by his reasoning, first post.
In composite, it is 3.
Composite, it is 3.
Yes.
In bifurcation,
clause is there, fiction is there. That will be treated as a separate institution. It's a fiction of law. Law says this post will be treated as this institution shall be treated as separate institution. If that is so, why does he say it is second post? Very often he has said that.
If I had but certainly I am entitled to the from additional 1/6/1988. I am entitled from 1/6/1993, my lord. I am not holding the second port. I am holding the first port. That is compulsory. Nobody was appointed prior to me.
When in what circumstance it will be treated as a separate institution?
For the purpose of granting it, my lord. That is the 1994 granted and notified, my lord. In notification, it has stated that which institutions are liable to receive the granted aid, my lord. As per this granted aid order 1994, the colleges were separated, my lord. Junior colleges came into post +2 course, and for degree course, it became a separate college, my lord. Because it will be easy for the government to release the granted aid in favor of the lecturer who are
regulation, like finance.
Yes. And this honorable previously has asked me, my lord, when I conducted the to file an affidavit regarding when the degree wing was recognized as by the government, my lord. I have filed that under Annex 7 by way of an affidavit that was on 30/12/89. It was given effect with the academic year 1989-90. And the B form was submitted, my lord, by the management, in which I am holding the first post of that I have filed, my lord. The affidavit.
What is it?
So for that, after bifurcation, that second post.
That is not I'm holding
absolutely without any basis.
May take in because we have not filed the counter here. Only relying upon para 6, 7, and 8.
This is the appeal.
This is appeal.
Question of filing the counter. It will go on the basis of the pleadings at section 24A.
Yes.
This is the 24
C.
B is the
tribunal. C is here.
C. It is the appeal in the C. No scope.
Question of filing objection will not arise at all.
At all.
Why tribunal said like this? What was your stand before the tribunal?
Well, this is at para 4 mila.
Para 4?
Yes.
Para 4
learned government additional government.
Para 2 mila. Learned additional government advocate. On the other hand, contended that the post of the appellant in third post of lecturer in the Odia was admissible to the college in the academic session 91 with the effect from 1/6/1991. The said post did not complete the qualifying period of 5 years prior to the commencement of the Amendment Act of 94. Therefore, the applicant is not eligible to receive JIA. Secondly, after bifurcation.
So your client only, has misled the tribunal.
This argument is irrelevant, my lord, because it became a separate college. Even if the third post is treated, third post I am holding.
Applicant is not eligible.
First
after bifurcation.
This argument is, my lord.
After bifurcation, both the junior college and degree college, the applicant have been adjusted against the degree college, against the second post.
Very second post.
Where is the second?
Second post is already occupied by Barik. Perhaps the tribunal was swayed away by the objection which your officer had filed.
Yes, madam. That has been by that. Without any basis, no document was there. My lord, I have given the document. And B form was submitted, my lord, in the affidavit. You will also kindly see it is on record, my lord. That B form for management is submitted. There I am holding the third post at that time.
I'll reserve judgment tomorrow.
Obliged.
Yes. Yes, that's right. Article 35.
Your Lordship,
Yes.
in the last occasion, I have submitted the copy of the judgment of the learned tribunal that is asked for. And today I'm filing the rejoinder, copy of which has already been served to the learned AGA.
Given it copy to the other side.
No, right now.
Yeah, today itself.
Today.
Yes.
Then he has to read it. He has to consult his officials and then come back. Okay.
You take time.
Or Monty, are you ready in the matter?
No, my lord. Right now we have received my lord served copy because in person appearing, let a date be fixed.
14% has filed a rejoinder to the counter filed by the other side. Come on. Rejoinder today to the counter filed by the other side. First, Mr. Monty seeks a short accommodation to go through the same and confer with the client, official client. Call in the second week of December. Any date, particular date to be given?
December, November will be okay. Also.
November, we have posted many matters.
Okay, December.
Otherwise, I would have posted.
For December?
4th December. All right. You have to come from which place?
I'm coming from Nirakarpur for that.
How many kilometers?
80 kilometers, sir.
80 kilometers. Yes, next.
Item 56 has been adjourned. Item 57.
56 is, I am there. 56. I'm for the
56.
It is adjourned in the morning.
I will, nobody informed. I am for the.
You should complain to the president of the Bar Association.
I am waiting for that because the person, they are not getting their legitimate claim. The money they have deposited, governing body has deposited 10 lakhs before this Hon'Ble Court. It has been quantified in our favor in the tribunal. We have succeeded. If particular period service we have rendered, that period of salary, we have to get it from the government. When the government sanctioned it, they have management has deducted it. Then now they have filed it. And moreover, the preliminary objection I have raised, there is no governing body when they have filed the case. That is why the last time the other sides have taken time to ascertain whether there is a governing body or not after getting my objection. That if there is no governing body, the principal cannot object our entitlement.
The government has sanctioned the money.
Yes, yes, it is there.
It is sanctioned as against the persons. Then how can management?
And government also clarified in that J order 2009, there is a provision. This where to get the block grant. The block grant has no linkage to the management payment, whatever they have made it. We have to get the benefit of block grant as per the 98 pay revision, whereas Odisha revised pension route, Odisha revised
anyway.
The
government has taken adjournment in your absence. See, therefore, you should have been here at 10:29.
Because I am here. I have 2 courts and today my position is very precarious. In the first case in one court, another item 3 in another court. I have to run. So I could not come. I usually come to this court first. We have met many matters.
Which date?
First week of December.
First week of December.
Is it on 4th December?
No, I already signed the papers.
Oh, that is 4th. Unusual melody is taking out first day.
Week, yes, first week means Thursday.
Thursday only.
Yes.
Item 57.
Yes, 57 I am there. This is though it is a very bulky brief. But
so you have made it bulky to threaten me.
I have to make it certain. So the only issue, as per my claim is, my lord, my claim against the person who has succeeded in the tribunal. I have gone to the tribunal for granted. Yes, wait.
Ready?
Yes.
Yep.
I have gone to the tribunal for approval and payment of grant. It's a quick for a peon postman. I succeeded.
Where is the date chart?
Date chart I have given. I have given one. Written notes from there is a date chart. It is there. One of copy I have.
This is the. I have given it. Let me place the dates.
Date chart is thicker than your.
No, because the court wanted everything, the note of submission also you give. So that is why I filed it. Only few dates, I will not read out everything.
What is the point in what?
Yes. One, my lord, in this case is the governing body or the managing committee of a school is the appointing authority. That is the statute. There is no dispute over that.
What so his approval is required, etc.
Yes. That's so the governing body has to be approved as per the statute by the competent authority. That is the
only then it becomes the
then it will be a statutory body. Then they can do all these things: appointment, termination, whatever the action they will take. Here is a case, my lord. There was a governing body. Whoever in at the time of institution of the institution in 1990, but thereafter the statute was amended. In 1812-1991, the state government brought in a new set of rules and abolished all the existing governing body. And as per the new rule, a governing body was in fact, management was approved on 15/12/1992. But some defect was there. That is why an objection was raised and it was modified.
was
reconstituted because there are two connotations my lord will get in that Orissa Education Act and the rules. The first is the institution was to be established. This is a basic, my lord. My learned friend might have been told in other cases. An institution has to be established by a body of person or a person which is known as an educational agency. That education, after the permission obtained from the government, you will apply for recognition. The institution will apply for recognition. At the same time, you have to send a proposal for constitution of the management because the agency is not the management. But what they have to do is they have to nominate some person as per the rules, that 11 members name, that this should be constituted. The first one, they have to constitute. That means the educational agency is constitute.
They send it to like a promoter of a company.
Yes, madam. They will establish the institution. They will nominate 11 persons as per the rules for constitution of the management, and that will give a seal of the authority that is called approval. After this is constitution, this is a first constitution. Thereafter, as many time it is be constituted, 3 years is the tenure of that governing body.
So 3 years it goes on being reconstituted.
Reconstitution. That is why the word is reconstitution. So the reconstitution in this particular fact, reconstitution was made. There was some defect. So that is why the competent authority has modified its order because there is some defect with the names and nomination. So it was modified on 28/12/1992. 15/12 it was approved. I have given all the dates, but I am just in short points I am raising out because we are short by times. So now against that, my lord, some of those persons, those who are initially in 15/12 body, they filed a writ petition in this school. That is OJC number at the relevant time WPC was the original jurisdiction case. OJC number 80 of 1993. They filed. There, my lord, there was an interim order of stay of the subsequent order. That is on 28/12. What the order was passed, modified order that was stayed in sometime in my lord 11/1/1993. That was stayed by this honorable court.
What is the what was 28/12/92?
28 November, that was modified. That order, shall I read, madam? 15/12/92, managing committee of the school was reconstituted and approved by the inspector of school by his order dated so and so. Inspector now redesignated as district education officer. So now 28/12, however, the inspector of school in his office order dated so and so modified the said order approval, reconstitution of the managing committee of the school and reconstituted another set of managing committee.
No, he constituted another set itself.
No, there's some common name, but there was another order that was superseded and the subsequent order 28/12/92 was the order.
No, two things.
Well,
a committee is constituted.
Well,
and subsequently it is approved.
Well,
committee will work for a period of 3 years.
Then it dies.
Natural death. Within before that, new committee is constituted. Again, approval.
Again,
Approval. Suppose what is meant by reconstitution? If somebody dies, new member is introduced. Is it a reconstitution?
No, exactly. There is no such word used.
Definition.
Like definition that for that matter that is not there, but the power is there with the authority to change the name. Suppose somebody dies, one member dies, they have to induct another. They have to induct.
Again, approval.
That needs approval.
So it is as good as reconstitution. Otherwise, the approval was
no. Once it will be reconstituted, again the term will be for 3 years. If there will be a change of one name,
that will not. But short that
the time period will continue with that from the day one. So what? But this is not the dispute here. What the dispute is, my lord, is like because in fact the OP number 4, there is a fraud committed by this so-called managing committee, whoever he is, either general valid managing committee or invalid managing committee. There is a peculiarity in the appointment of this opposite party against whom I am fighting. My land friend is API. He got an appointment order that at the hands of that governing body. That governing body has been stayed. Now they have passed an order appointing a person today, suppose, with a resolution of there, because first the resolution has to be passed by the governing body. We want to appoint Mr. S.K. Das. Thereafter, an appointment, formal appointment order will be communicated by the secretary of the managing committee. That is the rule. What is done? The secretary has issued an appointment order in favor of the other side by giving a future resolution after 8 months. That is the entire case. But the land tribunal held to
fabrication of record.
Yes,
according to you.
Yes, and course of hearing also before the tribunal. This is the second round of litigation here.
Why tribunal did not was not
considered? Very peculiar. I don't know. Can you see the date? It says that document.
Let us see those documents.
Yes, that is, my lord. I'm just because this is voluminous. I have to see and give the page, my lord. The page 147. The running page 147.
Whether the secretary is the appointing authority?
No, he is governing body. He is the agent. Yes, corresponding agent. Corresponding agent.
The policy decisions, all such day-to-day affairs are looked after.
Everything is by the body, by the governing. He is the appointing authority as per section 7.
So governing body should have passed the resolution. Then should give effect to resolution by issuing the appointment.
Appointment order. Corresponding. That is the law. That is the law. So everywhere, my lord. That is formal, very fundamental.
But here he issued appointment order
by referring to a future resolution, and he has corrected it.
Give appointment order date
is 147.
147.
Yes, running page I have read.
1912-92.
Yes, my lord. Kindly see the tenor of that letter. There is also proliferation in the name. The name was Pratap Kumar. Somewhere it is Pratap Chandra. I am not going to that details. Kindly see, man. This is the appointment order of this opposite party. The engaged
27/12/92.
Yes, 19/12/92 is the date of appointment. Reference is to resolution number 35 dated 27/12/92. This is my first objection. Was before this. And further, when this point was raised to the tribunal, because what happened, this case was initially before the tribunal. Tribunal pursued matter, passed an order against me.
What was his explanation for this?
No explanation what they have done. When I raised this objection before the tribunal in the first occasion, because that in this case went to this honorable court in another appeal. Appeal was set aside on this ground. Again remitted back. Again the tribunal committed the same mistake, not considered this aspect. Dismiss my case. I am before my lord. So what they have done? They have stated. Yes, madam.
Where have you contended that this is a fabricated?
Yes. Everywhere, in my entire appeal. Yes. Now, can you see that is why they have filed that my panel turn to page 163. They have filed a corrigendum to justify that no, it is a mistake. So the resolution they have referred to, kindly see, corrigendum 163
is filed by the secretary. Or
yes, again the secretary. Who was not the secretary because there is a stay order.
Resolution itself for the reconstitution of the committee was
stayed by this honorable court.
In WP number?
OJC number, my lord.
OJC number?
80 of 1993. I have given the order copy also. That is ultimately also dismissed by debarring this person who has done this mistake. That name is some Kanhucharan Naik, who is the helm of the secretary. Sorry.
OJC 80 of 93 was filed by whom?
filed by those persons, because in the first marriage, those means the opposite party filed by this
committee members.
Committee members.
Why they filed?
Because initially they were there. 1512, the managing committee was approved with Kanucharan and others. They challenge when
They challenge
12, another set of person come.
Another set is introduced by the officer.
Authorities, both by the authorities. So the authorities order was challenged in this OJC number 80 of 1993.
2812-92 order.
Yes, I have given
Which
it.
order was challenged?
This 2812, my lord. 2812. The order.
Say so.
I have given that judgment also.
No, in the judgment, whether anywhere it's mentioned.
Yes, finally see the judgment, entire judgment I have given, because that was disposed of finally. Though it was initially there was stay order, finally disposed of on the kindly page 101, my lord. The judgment I have given. I'm just giving the dates.
101?
Yes. That was disposed on 23 July 1993. 23rd July 1993.
103.
101, which started. Judgment in OJC 80 of 19.
Why two OJCs?
Which one, my lord?
103 page 2 is 80 and 6687.
1087 is the headmaster. All these facts I have given it in the tribunal. That's why I filed it here. That is with a different context. So for this governor is concerned, the headmaster, there were two headmasters. That is why one headmaster came before this honorable court. This honorable court allowed that person to continue. This was the dispute. I will clarify, my lord. Kindly see this first, where my lord put a question. The first, my lord, kindly turn to this page 97, where the stay order was granted in this OJC 80 of 93. Stay was 11/1/1993. This 28/12/93 order was stayed.
But stay was in favor of the OPs.
OPs. Yes. The second order.
Here.
OPs here. Yes.
So that will be.
No, OPs. No, now the OPs is a employee. This is. I'm just taking out the facts. I am an employee. I am a peon. We are the victims of these disputes. That is why I am bringing all these facts. We are not the management man. I am an employee. I have been appointed. So now I am just showing this. My lord, want to see the entire judgment?
I don't know.
Yes.
Who were the petitioners?
Petitioners are.
OJC is filed under which section? OJC is 226,
226. Now the nomenclature is WPC. Initially it was in our Odisha ballot, it was OJC, original jurisdiction case, the nomenclature. Now it is WPC. Can you see, my lord, page 101, who are the persons? The four persons, the managing committee of Gram Panchayat High School, Silo, represented through Secretary Sri Kanucharan Naik, Sri Dasarathi Sahu, Sri Bipin Bihari Khuntia, Sri Alek Khuntia. These are the four persons challenge the order. And
what happened to the challenge?
Yes, so that order I am showing, my lord. That order starts with page 100.
Why 100? One line will be sufficient.
One line. This is virtually this rendered infructuous. But kindly page 108, page 108. Because by the time 3 years time is over, in 99 it was disposed of. But the stay order was also initially vacated in between when it was in force. So that new management has also acted upon. So now
they said
reconstitution managing committee, but there is a rider. If the kindly see, my lord.
If will not take any of the persons mentioned in order number 3799, order dated 3770.
Yes, because they have these persons, those who have challenged this order, they have sent a proposal in their name. This Kanucharan Naik and others, the four names I have read out, they have sent a name. Court has debarred them. These persons should not be allowed to function as the member of the managing committee. Those who have,
it did not say petitioner, appellant, petitioner, etc.
In that proposal is there.
Only say
yes,
the list of names in the order dated 3797.
That's been quoted in that order itself. 37 order is quoted. The names I am saying, my lord, because that is in the cause title, my lord, got the names. And the date is that page 106, 37/1996. Kanucharan Naik, Alek Khuntia, Bipin Bihari Khuntia, and another person was this Bipin Bihari Dasarathi Sahu. Dasarathi name is not there. But these three persons out of this total. which has been recorded in there. They are DBAR. And this Kanucharan who was DBAR, he has done all, because he has done all this nuisance, this Honorable Court has come to the conclusion, such type of person should not be there in the managing committee. In fact, why I am saying this, all this, because this Kanucharan Nayak, claiming to the secretary, done all these things. This first, that appointment order I have shown to my.
That stay order was vacated. That they had suppressed.
Yes. That is why that was submitted a proposal and again that was reconstituted. That is why the court has interfered.
Vacated on 11/1/93.
Yes.
Or grant, huh?
No, granted.
Vacated 11/1/93.
Yes, that I am telling the dates. Not vacated. About 2 years. 95, sometime in 95.
1812/95.
1812/95.
1812.
I have given it in that chart, it is there.
I also give that in that I mentioned. 1895.
Let us.
Well,
I have made just a few notes.
So let us continue on some other date, madam, because it will take some time. That corrigendum, I will start from that corrigendum.
Corrigendum is issued by the secretary.
Yes, Sam, Kanucharan Act. They can finally see that page, or at least that page, but thereafter, my lord, finally see. I want page 163.
163.
Yes, that is a corrigendum.
Go to 163.
That is a corrigendum is updated on 28/12/1992. They made it antedated because the case was heard in the tribunal sometime in much after that. They have antedated it, filed it in the tribunal. But kindly see, this corrigendum is issued to correct the appointment order dated 19/12/92 issued in favor of Pratap Chandra Raut as a mistake has occurred in the body of the appointment order 19/12/92 by managing resolution number 35 dated 27/12 instead of resolution 30 of 13/3/92. This is the statement they have stated. But this is also not correct. I will show from the pleading by the authority officer and as well as the managing committee appear in that particular case, they have stated 2 other dates. And moreover, on 13/3/92, there was no approved managing committee. Approval has come only in 15/12/92. So there was no approved managing committee. How could you decided to appoint a person on 13/3/92 and given him appointment 19/12/92? These are the questions to be put by.
No, 18/12/91, there was a committee.
Yes, there was a committee. Which given appointment.
Maybe that
is a whole committee functioning at that time. And everything decided on appeals committee in similar matter. Everything.
That is something different. I will
totally same matter. This same school.
My mind is in a hurry.
No, not hurry.
I am not in. I will place your Supreme Court order also.
Yes.
I was there in that case.
Yes, that I only give to minor notice.
That is different.
Yes.
The court will not hear everything.
No, Mr. Das. The first committee was constituted on 29/11/1990.
Yes.
The duration, tenure is 3 years.
3 years, but by a clocks of time on 18/12/1991, the state government amended the rule and superseded all the managing committee. That is the rule. 91 rule has come. Odisha Education Establishment
of law, they are abolished.
Is over. So that is why
the committee was constituted
on 15/12/92 as per the new rule.
15/12/92,
which was again changed on 28/12 after 15 days or 10 days. 30 days.
So according to even as on that date also no resolution could have been.
13/3, how could there was no managing committee? And moreover, these 2 managing committee had filed the counter in the tribunal. They have stated something else with regard to this appointment.
What secretary said?
No, that is also not correct. That is the point. I will continue, my lord, some other day. But there is an interim order, my lord. It is an interim order.
That's let him bring it next time also.
My lord. I have discharged duty without salary. Then yes, teachers small debt can live it now. Teacher debt, my lord.
Next date of hearing. But why salary is being stopped?
No, but there is the entire thing is about a fraud. There was all through not here I have got an interim order. Interim order there before the tribunal also. This case is way back in 2008 it was filed. From that date it is, if you will get what I will get. The tribunal has also granted stay. Not that I am getting here. And this court also granted stay. That is, yes, sir.
One matter of the fixed date, on request of Mr. Prathraj and Mailers to December. There is a matter relating to sexual harassment by the principal. There Mailers observed that yes, the government already inquired
of December.
No, 2nd of November.
November.
It was actually
2nd of November, I may not be there. From till 10th, I am not. I may not
maybe
be.
taken up in 11th. Maybe taken up in 11th.
11th.
In the meanwhile, government has already issued the ballots, order ballots. Whether they have complied that order or not, I will serve a copy, let them take instruction in that.
On the 2nd of November, 11th of November will be.
item 57 fixed date, my lord. This item.
That's the second week of December.
I am not getting salary, my lord.
You are not getting from 8 I am.
For not that. Sir, any last week of November, my lord.
Now it will be
November not possible. Mile.
62 minus.
Yes.
60. Any date according to convenience of the honorable.
Which year matter it?
Nothing. 2011.
2011?
Yes. Because I am for the opposite party. The petitioner is not present here. He has left. So any date.
In the first week of December?
Yes.
First week of December.
Item 59, there was an interim order. Item 59. Interim order.
Well, item 59, I am for the respondent of file book, but not name is not inserted in college. Ajay Kumar.
His name is not reflected.
Registry to show name of C.
I beg pardon. Item 61. A fresh admission.
Fresh admission.
And that is a fresh admission.
What is that matter about? 50?
Yes, my lord. This case is challenging the tribunal's order.
61.
61 by
2025 matters.
Yes.
Any urgency, brother?
Beg pardon.
Any urgency?
No, my lord, she is going to retire.
The senior is saying notice has not gone.
Notice has not gone.
Notice has not gone, my lord.
Not gone means notice is not yet issued or notice has not gone.
No,
Issued, but
it has not
gone.
been issued, my lord. Your lordships have to.
But today is it better for issuance of notice?
Fresh matter.
Fresh matter.
Fresh matter.
First time issue emergency notice. You appear for whom in that state? Is not a party.
Beg pardon. Yes, only state.
Only state.
State and the yes, governing body is there.
Issue emergency notice. For OP number 1. And except for notice to OP number 2.
The governing body is opposite for number.
So number 4 is the governing body.
Except 4 government rule for all.
1, 2, 3 today.
What has fixed the
Issue emergency notice to.
Except my lord, the item 62, my friend mentioned, my lord. Lordship has fixed a date, my lord, which is a longer, a little bit where they going to retire and will not pay the pension. My lord.
Let us see tomorrow. In fact, I said I will pronounce your judgment tomorrow. The other matter, I do not know about how much I can do. I will try
Only by
first one. Let us one by one.
Month of November, your lordship fixed.
November not possible.
After December, my lord, that will be holiday, my lord.
Why after December?
That your lordship. But I have been told that after December, your lordship fixed.
30th December.
Oh, no. First week.
13th, 1-3.
1 December.
Item number 60. 60, my lord, I am for the interveners. My approval has been stayed by the Honorable State Education Tribunal as well as this Honorable Court. I am suffering. The dispute arises, dispute between the appellant and respondent 6. We are not least concerned. But in the approval order, my name as well as appellant and respondent was there.
In this case, I am appealing for the appellant.
Which was stayed.
Not the parties there. And I have also filed application by
I have filed the intervention petition.
They are not
It has been second week of December.
Yes, ma'am.
November may take up.
Second week of December.
Interim or to continue. Interim or to continue.